Is there an appearance for the parties? Switch on your mic, please, Mr. Chairman.
Thank you. Thank you. Morning, everybody. I appear for the first of the applicants, together with my learned juniors, Mr. Peter and Ms. Pue.
Thank you, Mr. Chairman.
Deputy Chief Justice and Justices, I appear together with my learned friends, Mr. Tsele and Mr. Cohen, for the Electoral Commission in all three matters.
Thank you, Mr. Bishop.
Good morning, Justices. It's surname it's Ramaidi. I appear on behalf of African Alliance, together with my two juniors, Mr. Mbeki and Villagas, in this matter.
Thank you, Mr. Ramaidi.
May it please the Court, I appear for the Labour Party with Milena Junior, Ms. Bero Manensa.
Thank you, Mr. Loxton. The arrangement is that the Labour Court will go first, Labour Party, sorry, will go first, followed by the ACT, then the ASD, and then it will be the Commission. So, but before we start, there's a condonation application which we can quickly get out of the way, brought by Mr. M, which is not opposed, I believe.
For the late filing of the record, there is a condonation application, and I don't understand the application to be opposed.
All right. It is granted.
Thank you, my lady.
Thank you, Mr. Yam. Okay. You can go ahead, Mr. Loxton. Oh, maybe I should place on record the arrangement that the interlocutory application, the fight about the replying affidavit and the answering / supporting affidavits will be, and the application to lead further evidence will be all argued along with the rest of everything, and you don't have to break to give a ruling.
That's correct, Justice Meyer.
All right, thank you.
Thank you. May it please the Court, I'd like to start at what we believe is the core issue in this matter, which relates to the narrative which the Commission has put up, which goes something like this. It says, it is true that you, the Labour Party, have been excluded from participation in the upcoming elections, but that is really your fault. You were tardy and you were inept. And to bolster that, there are three submissions, effectively. The one is that the system worked perfectly well because there are reports from the system provider that said so, 100% uptime. Then there is only a small handful of people who were unable to complete uploading the information by 5 o'clock on the 8th of March. And finally, there's the argument that if some people could achieve it, then you could too. And it's important to bear in mind that we are dealing only with unrepresented parties, because it was only unrepresented parties by virtue of the amendment to the Electoral Act who had to upload signatures of supporters. And we submit that that central submission by the Commission, namely that the system was working really well, and that those who acted reasonably and with due diligence could comply with the requirements, has a fatal flaw to it. And I'd like to take you immediately then to two attachments to the answering affidavit. I'm going to be dealing mostly with the answering affidavit, and that is PSM 24 and 25. And in PSM 24, And unfortunately, none of these have paginated numbers, so I'm afraid the court will simply have to find it. In PSM 24, which is a letter of the 25th of April 2024, attorneys for the Labour Party wrote to the Commission, and in that email, they asked for a report which lists the names of all the parties who are contesting the national elections, the names of new unrepresented parties who are contesting the national elections and successfully uploaded all the relevant information onto the online portal by the deadline of 8th of March 2024, and the names of new or unrepresented parties who were registered, however, have been disqualified from contesting in the national elections, and this part is important, as a result of not being able to upload all of the relevant information onto the portal by the deadline of 8 March 2024. There was a response to that at PSM 25, and in that response, the Commission said, well, the attorneys for the Commission said, paragraph 2, our client does not accept that your client is entitled to demand the information it seeks in your letter under reply, and in the manner it has sought to do so. That notwithstanding, we write to advise that the relevant information sought in your letter will be contained in our client's answering affidavit, which is in the final stages of preparation. It's then important to turn to the answering affidavit to see exactly what was said. And you'll find that at paragraphs 103 to 108 of the answering affidavit, and that is at page 34 and following. And this is what the Commission said. It said that on the 25th of April 2025, after this court issued directions, the Labour Party's attorney sent a letter to the Commission's attorneys requesting that the Commission put up in its answering paper certain information. The letter also contained a series of questions, and then they attach a copy. Because the Commission does not wish to be accused of hiding potentially relevant information, that is important for what I'm going to say in a few minutes. And because it believes its obligation is to always play open cards with political parties and with this court, it will provide the information. For ease of reference, I attach the Commission's brief response, PSM 25. And you'll recall that what was sought was the names of the parties who were able to upload, the names of the parties who were not able to upload, those are the unrepresented parties, and the numbers. So they then go on to quibble about why the information is sought. They say they don't really think that we need it, and we've actually asked for it too late, and they reserve the right to respond to any allegations or case that may be made out in argument or further affidavit. However, this is what they then say at 108. However, I note the following from the information. 33 unrepresented political parties will contest all elections. 18 will contest only provincial elections. I attach a spreadsheet, which is PMS 26. Then at 108.2, 18 represented political parties that sought to participate in the national elections did not meet the requirements to do so. And then they say only 5 of those, Labour Party, Arise South Africa, African Alliance of Social Democrats, and Defenders of the People, have challenged the Commission's system decision. The calculation, which is then done using those numbers, indicates that there was 64.7% of the parties who attempted to upload the information managed to do so by the deadline. 35.3% were unsuccessful. In their heads of argument at page 36, para 99.2, the Commission acknowledges the correctness of that calculation. they give you a figure of 35% failure. Now, when you have a look at the answering affidavit and you have a look at the Commission's heads of argument, you will see there are frequent references to a handful or a very small minority of parties who are unable to upload the information in time, that the vast majority of those who were required to do so did so successfully. That's just untrue. 35% failure rate is not a small minority, and 65% is not a vast majority. What it indicates is that despite the glowing reports from the service provider who said their system was working well, and the argument that if some could do it, all could do it, there were significant difficulties. If a bank, for example, were to put an app out onto the market, and they found that 35% of their customers were unable to use the app, they would withdraw it. They would reach the conclusion that whatever its merits, it was not fulfilling its purpose. And however much their IT people told them that there was nothing wrong with the app, the proof would be in the pudding how many people could actually use it successfully. There's another aspect to this, because you will know that the Commission has said that the majority of the Electoral Court found fairly firmly that the evidence demonstrated that the problem was not with the OCNS, but it was with the Labour Party, and indeed the same decision was made in respect of the other parties that were before that court. But what was not disclosed to the Electoral Court were these figures. And it is somewhat surprising that the Commission, having identified its desire to be open and to be transparent and to disclose material information, did not disclose these figures. These figures go to the heart of the problem, because if these figures are an indication of what the experience of parties were trying to use the system, then the system was not working as it should have. And so this is not a matter which is a dispute of fact, which cannot be resolved between the Commission on the one hand and the Labour Party on the other. It's the Commission itself which has now disclosed at a very late stage in its answering affidavit that its statements that the system was working perfectly well and that a very small minority couldn't use it is simply not true. And so the Commission itself has demonstrated why it is so that the parties who were denied the right to continue the process of qualifying for the elections were denied it on a basis which was unlawful and which amounted to a transgression of their rights under Section 19 of the Constitution. Now, there are luckily not many things in dispute in this matter. As I understand it, certainly urgency is not in dispute. And it's not really in dispute that this matter raises a constitutional issue. And so the direct access to this court is really based on two arguments which the Commission raises. The first argument is one of issue estoppel. Now, what the cases show us quite clearly is that the default position is that in our law, a party who wishes to preclude the further adjudication of an issue that's already been adjudicated must satisfy the requirements of res judicata, which is the same issue, the same parties, and the same relief and the same cause of action. It is possible to relax those requirements and then to raise what has been called issue estoppel, where it is the same parties and the same issue of law or fact which must be shown. But what the courts have cautioned against is the extension of that, of issue estoppel in cases where it would cause prejudice or unfairness. And in this case, what is sought to be done is to preclude the hearing of this matter in this court, the question which has been put up about whether or not the holding of an election would be unfair in the circumstances of precluding the Labour Party and others from participating. That, they say, was finally determined by that court, by the Electoral Court. And we say that on a reading of the cases, particularly the Prinsloo case, you will see that issue estoppel is really not something that the Commission can raise. They haven't demonstrated why in this matter res judicata should be relaxed, the principles of res judicata should be relaxed, and why issue estoppel should be applied. Also, it would clearly result in unfairness, and it seems to be anomalous to preclude the decision of this court on a constitutional matter on the basis of issue estoppel. So we don't believe that there is any merit in that argument. The next argument is that the Electoral Court is the final court, and that no appeal may be brought against that court in respect of any electoral dispute. Look, so the first difficulty, of course, is not an appeal, but the second difficulty is, as is pointed out by the Commission in its own heads, that does not apply where the issue to be decided is a constitutional issue, because if the Constitution appoints this court as the final arbiter of constitutional issues, it would be anomalous to conclude that the Electoral Act, in fact, appoints the Electoral Court as the final arbiter of all issues, including constitutional issues. And as I've said before, there's no debate that this matter raises a constitutional issue. The next defense that is raised by the Commission is that this is a matter where there is dispute of facts. I already indicated that this is not a matter where there's a dispute of fact between the applicant and the respondent. This is a matter where the respondent, the Commission, has itself demonstrated in its own answering affidavits the merits of the case put forward by the Labour Party. But even that approach, that this court will not hear matters where there's a dispute of fact, and so, in fact, the argument goes that by the Commission, ought not to hear this matter. If one looks at the Bliss-Brands decision of this court, one would see that it's much more nuanced than that. First of all, those pronouncements of this court in relation to determining disputes of fact have been applied, as far as we can see, in cases where there is an appeal, not in cases such as this, where there is direct access, not access by way of an appeal. The second is that it's nuanced because what was said in Bliss-Brands was that it isn't that this court cannot decide questions of fact. It is that it ought not usually to do so. But if justice requires that it do so, it will do so. So to the extent that this court is required to decide whether, despite what we have said, there is a dispute of fact between the Commission on the one hand and the Labour Party on the other, the court retains the power to decide such a dispute if it is in interest of justice to do so and necessary in order to give effect to its jurisdiction. There then are some minor issues which remain. I'll deal with them very briefly. They are the question of the reply. It is true that that Rule 18 does not provide for a replying affidavit. But of course, and we have not brought a formal application for its admission, for leave to admit it, but of course there was no time to do that. So we've asked that it be admitted in the interests of justice in the affidavit itself, and we think that the objection by the Commission is really a technical one. There is a further point. And it does not seem that it is a matter which has been considered by this court before, and it is this. Rule 18 deals with direct access, and as the commentary to the rule points out, normally you would imagine that matters of direct access would be dealt with in two parts. The one is that the court grants direct access, and if the court grants direct access, then the second part is to determine the merits of the substantive application. But generally speaking, as far as we can see, and certainly in this case, the invitation by this court, as in the case of leave to appeal, is to deal not only with direct access, but with the merits of the application, with the substantive relief that is being sought. Now, applications for substantive relief are not dealt with in terms of Rule 18, they're dealt with in terms of Rule 11. Rule 11 does in fact provide for a replying affidavit. And so where you've got a two-part application, one for direct access, the other for substantive relief, it is, we believe that on a proper interpretation, you would then look to Rule 11 for the substantive part of it. The next aspect is the supporting affidavits that have been filed by various parties. We don't really have a say in that because that doesn't affect us directly. Having had a look at the argument put up by the Commission, however, it seems to us that they have the law wrong. The law is not that a responding party must either abide or oppose, or if it wishes to support, it must bring an application to be joined as an applicant. It seems to us to be perfectly permissible for a responding party simply to support the statements that have been made by the applicant, because if it were otherwise, then a responding party who simply wanted to say, we've read the affidavit of the applicant, we think that they're right, wouldn't be able to do so. And we think that that is not what our law says. The cases that are referred to are all cases which deal with occasions upon which the respondent actually sought relief, either the same relief as was sought by the applicant, or, as in Minerals Council decision, different relief from that sought by the applicant, and in fact, in that case, relief against a fellow respondent. The usual requirements of direct access, urgency, that it cannot be determined by another court in time, and consideration of the merits and the various other aspects. It seems to us that there is no objection to direct access other than an objection to access at all. In other words, other than this is a case involving a dispute of fact, that there is a problem with res judicata, or in this case, issue estoppel, and that the Electoral Court has final jurisdiction. And so it seems to me that if those defenses fail, as we believe they should, then there can be no objection to direct access at least. The second question is whether we're entitled to the relief sought. What the Commission has said is interesting, because they've said that if you find that the problem was with the system, then the relief sought by the Labour Party is the correct relief. And in this regard, I can refer the court to answering affidavit, page 46, paragraph 146, where this is what is said by the Commission. It says, nor is there any legal dispute between the Commission and the Labour Party. The Commission accepts that if the OCNS failed, the applicant is entitled to relief. It just denies on the facts that the OCNS did not work, or that it caused one applicant's non-compliance. A similar statement is then made a little bit later at paragraph 149. It says, if this court upholds the appeal, it's not an appeal, but anyway, questions what remedy it should grant. In that event, the Commission largely supports the relief sought by the Labour Party. So, although in the heads we see now that the Commission has tried to distance itself from those statements and those concessions, and says that a mere declarator might be enough, we say that that would not solve the problem, and it's an unjustified departure from a clear acceptance in the answering affidavit that the postponement that we ultimately seek is justified if this court finds in our favour that participation was denied because of the failure of the system on the particular 2 days. And then finally, there also doesn't seem to be any objection to...
Sorry, it's me.
Yes.
No. I really need clarity. I can see that you looking at the fact that this is your protected time. I need to find the pages that you're referring to in the answering affidavit.
Oh,
it's
yes.
Not a question.
Sorry,
yes.
my apologies. The answering affidavit, it's page 46, paras 146, 149, and 150. So it's 46 and 47. Thank you, Justice Cheeky. So the final submission that I wish to make is that there doesn't seem to be an objection to the form of the relief that is sought. And the form of the relief is taken from the Electoral Act, because we took the view that it would not be within the powers of this court to order the President directly to postpone the election. It would be within the powers to make the declaratives which we sought, and then to direct the IEC to request the President to postpone the election, because the election, if held, would not be free and fair. Thank you. Those are my submissions within the 30 minutes.
Thank you, Mr. Loxton. Do you have questions for Mr. Loxton, please?
Mr. Loxton.
Justice Matlanga.
I have difficulties wrapping my mind around the procedure that the Labour Party has adopted, that is coming to us by way of direct access instead of an appeal. Perhaps let me ask this first. If we are against the Labour Party on direct access. Does the Labour Party have any application at all before us?
No.
All right, thank you. Why is it that Section 1721B of the Constitution could not have been applicable to obtain the relief that the Labour Party is asking for?
Sorry, that's sections 172?
It's 1721B.
Justice Matlanga, we took the...
Is
yes.
Just an equitable...
Yes, we took the view, that is a debate which is on the papers. We took the view that because on the facts before, two reasons. First of all, this relief was not sought in the Electoral Court. Secondly, we couldn't seek that relief before the Electoral Court because those facts didn't exist at the time that the Electoral Court reached its decision.
Those what?
The facts didn't exist. So we believed that it was unlikely that this court would exercise its powers under Section 172 to grant the relief that we sought if the facts before the court below didn't exist and only came into existence at a later stage.
Just itemize those facts for me, please.
So the facts are that when the matter was before the Electoral Commission, the float of 4 days that was asked for could have been granted. The facts did not justify a postponement of the election as a whole, because within the timetable, the Labour Party believed that the lesser interference with the electoral process would be to ask for those extra days. By the time the Electoral Court granted its order, which was against the Labour Party, the facts had changed because it took so long, that process took so long, that by the time the judgment was given, no postponement was possible. And there we agree with the Commission that at that stage, only a postponement was a suitable solution.
But the core issue really was the question whether the OCNS, was functional. That did not change. I do not see why an appeal could not have been brought on the basis that the Electoral Court was totally wrong on the facts, at least according to the Labour Party. Then the question of the relief is something that the Labour Party could then have applied its mind to. And sitting here now, I don't quite see why Section 1721B would not have been applicable. That's not final, that's just a prima facie view.
Yes, and as I say, look, it's a difficult question. The extent of the powers under 172 and whether this court would have been prepared under 172 on appeal to grant an order which the Electoral Court couldn't grant, was not asked to grant, and would have not been justified on the facts put before it. We took the view that it was unlikely that this court would grant the order that we sought. Bearing in mind, too, that the Commission takes the view that there is no appeal to this court from the Electoral Court.
Lastly, from me, the way in which the Labour Party has approached the court and the issues that I'm engaging you on have practical implications. How, for example, do we deal with the factual issues? Do we deal with them as if this is a matter at first instance? Which would be quite odd because with regard to the other two parties, we will have to engage with the facts on the basis that they are coming to us by way of an application for leave to appeal. Just how do we deal with this?
Yes, so on the question of the dispute of fact, we don't believe there is a real dispute of fact.
No. I'm not engaging you as to what we should decide with regard to the facts. I'm engaging you at a jurisprudential or juristic level. How do we, as a court, deal with the fact that this one litigant comes to us purporting to be litigating at first instance, and there are two other parties who, leaving aside the factual detail, are roughly similarly placed as the other party. They are coming to us by way of an application for leave to appeal. And you know what the jurisprudence says with regard to how a court of appeal deals with factual matters that have already been decided by a court of first instance.
Yes.
Now, in the Labour Party's case, do we deal with those factual issues as if it's a court of first instance? And what do we do about the incongruence? Because with regard to the other parties, obviously, the facts must be dealt with on the basis that it's an application for leave to appeal.
Justice Matlanga, each one has chosen a path. There will be consequences for those choices. The fact that certain parties chose to go by way of leave to appeal, another party chose to go by way of direct access, is simply a result of different choices. And so this court will deal with each on its merits and on the basis of the choices made. And so in respect of the leave to appeal applications, you will deal with it on the basis that you cannot or ought not to be asked to depart from the factual findings made by the Electoral Court, because that is not your function as the apex appeal court to decide those disputes. In a direct access, you have a broader remit in relation to the facts.
It sounds odd, but you've made your submissions. Thank you, Mr. Loxton.
Thank you, Justice Matlanga.
Mr. Loxton, this side. I'm here, Mr. Loxton.
Sorry, there's an echo of the wall there, Justice Matlopu.
Yes, it's Majid. Mr. Loxton, would you just switch off your microphone? I'll be more audible now when it's off, and I'll switch off mine when you answer. I have a number of questions I must forewarn you, but let me start with the one that my brother Matlanga engaged you on. I share similar concerns. This is not the first, not the second, but this is the third direct access application that you bring. On the same set of facts, more or less, I qualify that, but for the same relief, also more or less, I'll qualify that. Because the first one was on the 6th of April when you went to the High Court, and you denied relief because they said you must go to the Electoral Court. You went there. And now you're here with a direct access application. It seems to me that this prejudices the Commission to a great extent, because the Commission can't respond on facts and evidence that was laid in your case in the previous proceedings in the Electoral Court, not so?
Justice Majid, I'm not sure that I understand that, because the Commission will respond in each case on the facts of that case. So in this case, they will respond on the facts that we have put up. The fact that the facts that are put up now may be more extensive or less extensive, there may be differences, would not prejudice the Commission in putting up a response on the facts in this case.
Let me explain. I get the impression, and please correct me if I'm wrong, that you're trying to avoid a set of facts in the Electoral Court, which prima facie, and I emphasize prima facie, seems to me to militate strongly against the relief that you seek. and I'll explain it later when I come to the factual disputes. So it seems to me by bringing this direct access application, you are avoiding a set of particularly adverse facts in a previous court where you sought basically the same relief, and that is the prejudice.
Well, there are two answers to that with respect, Justice Majid. The first is that the application to this court for direct access is not brought in order to avoid the findings of the Electoral Court. It is brought because it was believed that the findings of the Electoral Court were of now academic interest because time had moved on and the relief sought was no longer relevant. That's the first thing. The second thing is when one talks about the facts before that court, there is a core fact not put before that court by the Commission, and that is that there was a failure rate of more than a third. Now, we find it extraordinary that the Commission would say we ought to stay with the facts found in the Electoral Court, and if you don't, we're prejudiced, although we did not tell that court what we have told this court. And we regard the 33% failure rate, 35% failure rate, as a core fact. There is no more important fact than that more than 1/3 of the parties who attempted to upload failed. So it would not amount to justice to say to us, you should have stuck with a series of findings which were based on an imperfect access to facts.
Right. Since you did mention it, let me turn to that. You drew our attention to paragraph 99.2 of the Commission's written submissions. But what the Commission says there requires some answers, because the Commission says that failure rate that you say is 35%. They say that there are only 3 of those parties before this court. Those are the applicants. And they say the others may have registered but never attempted to upload the information, or they, like the applicants here, may have left it to the very last minute. Is that not a reasonable explanation, possible explanations?
Sorry, Justice Majid, I'm just looking at what they're saying here. In 99.2, is that the paragraph you're referring to? In 99.2, they say only 35% that sought to be registered would not be able to compete. That is not evidence the system failed, but it worked. The reasons why 15 of those 18 parties failed are not before the court. But that's not being true to the answer they gave in respect to the question. The question was how many parties were unable to upload. They gave their answer. They said it was 18. So you must accept that when they say it's 18 unable to upload. Now we can't go into the reason for each one. So we've got to look at it collectively and say if only 65% of unrepresented parties were able to upload the information, then the system is not working. Unless you're going to say that 35% of the parties were either lazy or inept. In other words, I'm sorry, but we're just dealing with a generally inept bunch of political parties, rather than saying, I haven't designed a system which will be effective.
I'm going to deal with the question of, because it seems to me the central issue, even if we treat this as a direct access case, which, as I've said, I have grave difficulties seeing it in that way for the way you've proceeded. But before I go to that, those factual disputes, how to deal with them and how we should resolve them and what the problems are with the OCNS that was proved, let me ask you about the interlocutory or the preliminary matters. Rule 19, you said Rule 18, but it's Rule 19, is very clear how applications are brought before this court for leave to appeal. And Rule 18 is the direct access application. Now, there's no provision for a replying affidavit in those rules. You accept that. Absent a substantive application, on what basis can this court consider further affidavits? I mean, there are two cases in this court, which is the Bytes Technology case, and the other one just escaped me, it's in my notes. That's plainly say why there's a rationale for the rule, and why there should be a substantive application, and why this court, as a rule, does not allow further sets of affidavits. It's simply this. It gives each of the parties one opportunity to file one set of papers, and then it has the judgment of the court whose judgment is on appeal, either the SCA or a high court or a full court, whatever the case, or the Labour Appeal Court. And so that is the reason for it. Why should the court depart from that established precedent and from its own rules?
Yes, Justice Majid, there are possibly two answers to that. The first is this is an urgent matter, and the very first prayer is a prayer that we be relieved from the obligation to meet the usual requirements in terms of form and time. And so bringing a formal application to admit a replying affidavit in these circumstances would have been pointless. By the time you've dealt with that formal application, admitted the reply, allowed a response to the reply if necessary, the time would have expired. So that's the first answer. Urgency is important. But the second answer, as I've said, the Rule 18 deals with direct access. It's a gateway. It doesn't deal with the substantive relief. This court deals with direct access, generally, as far as I can see, on the basis that you must deal with merits and direct access. But merits are dealt with in Rule 11, which does allow for a reply. So that is the other answer to your question, Justice Majid.
See, what I thought would happen, because you are dealing with an urgent application, you would file that substantive application, and you would include the affidavit on the basis that that will be argued at the hearing. And what this court has done, as you've seen in this main application, is there's much abridged timelines for responses once those come in to accommodate everybody. But I'm leaving that there for now. All these other affidavits by the respondents, I think you are right if you say that, if you simply say, I support the relief sought, then there's no need to bring a separate application. But surely when you adduce new facts and you come with new grounds, in addition to those advanced by the applicants on which you seek the court to hear you, surely it can't be right. In the rules of the game, we all know how litigation works. There's a founding affidavit, there's an answering affidavit, and then there's a reply. To slip in or to sneak in substantive new averments on the substantive merits in what is called answering affidavits precludes, exactly because there's no room for replying affidavits or any further affidavits in this court, precludes the Commission from answering them. Surely that's highly prejudicial.
Yes, Justice Majid, if I may answer that in three parts. Firstly, it seems to us that any respondent is entitled to say, I have read the affidavit of the applicant, and the facts that it set out are, in my experience, correct, and here are some further facts which support that. I have had the same experience. What they're not entitled to do is to say, and I seek this relief, because they're not an applicant, they can seek no relief against a fellow respondent. The question of prejudice would be dealt with, because this is not an unusual event. It's quite often that you'll find, in fact, it's what happened in the Minerals Council's case. So what happened in the Minerals Council's case, there was a joinder of a lot of respondents at the insistence of the minister. The minister probably regretted that because many of the respondents supported the applicant. Now, if you find yourself as a respondent in a case where you've got new facts raised by a fellow respondent, your remedy is to apply for leave to file a supplementary answering affidavit dealing with those new facts.
The last area of my questions is this factual dispute. If we treat this as a direct access application, do you accept that we have to apply Plascon Evans unless we can reject the Commission's answers as far-fetched, untenable, and so on?
Yes.
But are they far-fetched and untenable?
Justice Majid, our position is this, that the Commission has itself established a basis upon which you cannot accept what they say when they say the system worked properly and a handful of people could not comply and the vast majority did. They have now demonstrated that that is incorrect by the figures they've given you. So it's not a question of rejecting a dispute between the applicant and the respondent because the respondent's version is far-fetched. It's that the respondent has undermined its own version.
All right, let me go to the facts. Do you accept that the online portal could be utilized by the Labour Party as early as 23 February of this year to do what it had to do?
Yes.
Did you do it?
Justice Majid, if you go through the papers, what you'll see is that as things progressed, the Labour Party utilized the system as best it could. It asked for assistance wherever it ran into difficulties. And I suppose let me give a concise answer to that line, and it's this. If it is the Commission's case that all of this could be done easily within one day, then all complaints that the Labour Party delayed in uploading onto that portal come to nothing.
I'm sorry to interrupt you. Let's just pause there. Here we have a party, duly registered, serious about contesting what the media tells us is going to be the most significant election since 1994. It waits until the 8th of March, the very last day, to start getting its ducks in a row. How does it do it? It chooses the most inefficient method, manual uploading. It has an online portal administrator and only one sub-user. It could have as many sub-users as it wanted to. So I would have thought, I'm not tech savvy, I must tell you immediately, but I would have thought from the little I know about computers and uploading information. I usually struggle uploading information when I have to do my SARS return every year. But here you have a party waiting until the very last day, not registering multiple sub-users when it chooses the most inefficient method, uploading. We are told that if you'd offline prepared a full spreadsheet, you could have uploaded all of it at once by bulk uploading. So on what basis? And then the last one. You have the other option. You're in Gauteng. Given the traffic, you're probably an hour and a half at maximum away from Centurion's head office. You choose not to go there. On what basis can we say that, let's accept there's a 35% failure rate. On what basis can we say that these explanations for the possible reasons why you have not complied are tenable? On what basis can we reject that as not tenable?
Well, Justice Majid, let me break that down. The I'm not sure what they would have gone to the head offices of the Commission for, because their difficulty was with trying to get through all the signatures that they had to upload of supporters, which representative parties didn't have to do. They are not allowed to do that by taking the documents to the Commission's office. It has to be done through the portal. You will have seen that the Commission said that we told them that we will ignore the law. It's a remarkable statement by the Commission, who cites cases before this court that it is bound strictly by the law and the regulations and the Act. And then to say we were prepared to depart from that Act and from the regulations, from the timetable. So that is an anomaly. But let me go back to the main point. The Labour Party committed significant resources for a period of 2 days where the Commission's case says it could easily be done within one. It is easy to say, but you see, if you had just looked more carefully at this function of the online system, at that function of the online system, or this or that, you could have done it better. The fact that 35% were unable to do that shows that the system didn't function as it was supposed to, which is to assist people to make themselves ready for the election and to upload the information. So we turn the question around. The question is not whether or not technically this system functions in a particular way. The question is, could it be used by ordinary people applying their best reasonable efforts? If it couldn't, if there are a significant number that couldn't do it, and there are, then the answer is it was not fit for purpose. And the fact that you can point in retrospect to all sorts of errors committed by the Labour Party in understanding the system, where the same errors are committed by everybody else, it seems, or different errors, but they all round up in the same place, demonstrates that it's not fit for purpose.
No, there were two parties. The one is the AIC, both unrepresented parties. The AIC had internal squabbles. Finally, they were able to approach the Commission with a letter to say, we are the proper, real leadership, and we want to proceed and register and upload. They were able to do so within 1 day. Then there's another party, the acronym escapes me, I think it's something like ELNF. There are so many parties, I get confused. But the point is this. You ask what purpose would it have served to go to the Commission's offices in Centurion? Well, those people, as I think prudent political parties or independent candidates would have done, went there and they were assisted by the Commission and they were able to register. Now here's the question. Is it an objective assessment whether OCNS worked, or is it a subjective inquiry as to your experience, the AASD's experience, and ACT's experience? What is the test?
The test is whether it's fit for purpose. That is a test which you can apply by asking what the proportion of the number of parties were that managed to upload the information in time. Let me give you an example, just to test the logic. Let's assume that the providers of the system said it was up all the time, there was no lagging, no kicking out of anybody, it all worked perfectly, and nobody was able to upload. The court would have absolutely no hesitation, I would submit, in saying it's no good telling us you have a perfect system if people cannot use it. They may not be able to use it because it may be too sophisticated for them. You may have created a system which is simply too complex, and then it's not fit for purpose, although it works as designed. And so our response to that, the objective fact is that it was not fit for purpose because of the significant number of people, for whatever reasons, different reasons perhaps, but the same result, were unable to participate. And if it demonstrates not fit for purpose at 35, then the same applies as you go up the scale. So at what stage do you say, if it's 70% failure rate, you say, oh, now I really can see this thing doesn't work, however good it might be?
We must be careful to get the perspective right and the context. When you talk about a 35% failure rate, we're talking about a 35% failure rate of unrepresented parties. The overwhelming majority of represented parties already in Parliament, as I understand it, were able to use the system. And so we're not talking about a perfect system. As I see it, the objective test is this. Was the system reasonably able to perform as it should by reasonable users who understood what had to be done?
I would qualify that proposition, Justice Majid, with respect. Because the represented parties did not have to upload supporter signatures and details, there is a whole different regime for them. The question would be, could reasonable, unrepresented parties comply with the requirements of the system? And the answer to that is, if a significant number couldn't, then the system is not fit for that purpose, for the purpose of the unrepresented parties, because it's those parties we're talking about. The represented parties has a much easier pathway.
Now, before I ask you about a matter that I forgot to ask you about, which is a preliminary matter, let me ask you the last question on the merits. When we talk about freeness and fairness of an election, which are national elections, these are elections for the National Assembly and for 9 provincial legislatures. When you talk about fairness and freeness, it cuts both ways, doesn't it? Are you going to say to 65% of unrepresented parties who were compliant, who did what they had to do, timeously, and you're going to say to an overwhelming majority of represented parties, with the advantage of not having to upload supporter signatures and names and so on, would you say to that 65% and others that it is fair that we postpone these elections? Are you going to say to the people of South Africa, with the economic melee that we have, with the severe financial constraints that we have, that it is fair to spend over R500 million to postpone these elections because 35%, maybe as high as 35% of parties, but at least the 3 before the court, couldn't use a system and tried to do so at the last minute, couldn't use a system where so many others did. Is that fair, Mr. Loxton?
Justice Majid, I'm going to answer it in 2 ways, if I may. The first is, one of the remarkable things about this application, which the court will have noticed, not one single political party has opposed it. Not one.
I think they're busy campaigning.
Well, that may well be, but if they were going to, if they really, really didn't want this to be postponed, and if they were going to suffer prejudice, which the Commission says they would have been here, the DA, the ANC, and the rest. They would have been before you to say, this is our prejudice. We've already prepared A, B, and C. How can this be postponed? They're not here. And so you can take it without speculation that they're not here because they don't feel strongly enough about the postponement to actually put up an answer. So that's the first part of the answer. The second part of the answer is this, that when you're comparing the postponement of election and you look at the prejudice to the system, our democratic system, and you compare it to the denial of participation of a significant number of unrepresented parties, then we would suggest that the scales tilt in favor of a postponement rather than a denial.
Yes. We're in the realm of conjecture, really, because I think some parties will say they don't have the money to litigate and they'd rather spend it on political campaigns. But let's leave that there. I forgot to ask you about this application to adduce further evidence, the lockdown IT by the Commission. Can I understand why are you opposing it? Sorry, that's about the IT experts.
I'm not opposing that.
The people who monitor the system.
Yeah, no, I'm not opposing it. It's not. We're not opposing that.
Okay, thank you. Thank you.
Mr. Loxton, is it correct that the Labour Party only captured its first candidates 36 minutes before the deadline?
It seems so, but that is because they were trying to capture as they indicated, it's no point trying to capture candidates lists unless you've got the supporters in. Without the supporters, the candidates mean nothing.
My question relates to whether they didn't start too late. Didn't the IEC advise that it would take about 1 hour to do this function?
Yes, but the reason for the delay, as I understand the papers, is that you could only upload the candidates once you had tried to upload the supporter signature. And you must remember what the evidence of the Labour Party is that they were being kicked off. So there'd be no evidence of uploading. That's successful uploading. There'd be no evidence of uploading if, in fact, what happened is that you kicked off the system earlier.
With the 36 minutes in mind before the deadline, even if the portal had not malfunctioned, would the Labour Party have been able to comply with the deadline?
Justice Turon, the reason why that was the period, that was the time period, was because of earlier malfunctions of the system. So they would have been uploaded far earlier had the system worked. And that's what the Labour Party has said.
In respect of whether the system was working properly, not working properly, is this court required to make a finding in respect of that?
I beg your pardon, Justice Turon, I was reading a note. Would you please repeat that question?
Is this court required to make a finding as to whether or not the system was malfunctioning?
I think what this court has got to decide is whether or not the exclusion of the Labour Party from participation from the elections is something which occurred as a result of their own ineptitude, or whether they were denied it because they were dealing with a system with which they couldn't reasonably cope. So, fit for purpose.
Very vague way of answering my question.
Fit for purpose. It comes down to, there will have to be a decision, was the system fit for purpose in the sense that it enabled the average reasonable party to upload that information on time. And as I've said, a demonstration that that is not so comes from the number of people who are unable to do it. You know, if you set an exam for a class, and the class is made up of a number of different kinds of people, average people, and you get a failure rate which is high, there'll be three answers to that. The teacher was no good, the exam questions were too hard, or the class is full of stupid people. Now, the Commission has given you this third answer to that, and we would suggest it's the second. The system was too complicated to enable sufficient number of people to comply in time. And it snagged, and it had its problems. And you'll find the Commission can't actually say it didn't do what you said it was doing. When you say on this day it lagged, on this day it kicked me out 3 times, that they can't deny. They just say, no, but other people could do it.
And at the end of the day, isn't that what we have before the court? That many others could use the system for the purpose that it was intended.
Yes, was it fit for purpose?
Are you asking me the question, Mr. Loxton?
No, I'm saying that's the test. Was it fit for purpose? But I don't mind an answer.
In the judgment, Mr. Loxton, in due course, you'll find the answer. What would your submission on cost be in respect of both scenarios, if the Labour Party wins or if the Labour Party loses in this court?
I haven't actually got instructions on costs, and I can't even remember what we asked for. I think we did ask for costs, and I think the Commission asked for costs. So I think that you didn't. Can I take instructions on the cost aspect, Justice Turon, and deal with it in reply?
Yes, thank you, Mr. Loxton. Thank you, Deputy Chief Justice.
Mr. Loxton, this way. Thank you. I don't know if you responded to Justice Majid's question earlier on the facts on why did you not use more sub-users?
As I understand, and I think the difficulties, I can't recall, but I think that issue came up in answer. So if we don't get a chance to reply to that, there's no answer. It comes up in the heads and it comes up in the answer. So the answer to that question is not in our founding affidavit, and I can't answer that question. It seems, though, that what happens is that the view was that it would have been sufficient to use one user with all the resources that were available. But the correct answer to your ladyship is that because of the way things work, that this is raised in an answer, there is no response to that.
Thank you. The reason it stands out for me is that if you accept, as the Commission says, that you only started 36 minutes before, I would have thought that the prudent thing is to then, increase your capacity as the Labour Court, as the Labour Party, in terms of using more users and in order to reach the deadline. But I will not pause you for an answer there unless you want to answer it. But I'm just saying it raises that question to me.
Yes, Justice Chiki, if you look at the papers of the Labour Party, you'll see that they start this exercise on the 7th, and they put 20 people, I think it was, into the process. And so the candidate, so they devote very substantial resources to the exercise. And the candidates list is the last step in the process. And if you can't get, if it's being difficult to get the first steps completed because of the faults that we have identified in the system, then of necessity, the last step is very late in the day.
Okay. Can I ask you on a different issue that you debated with my brother Madlanga. If we allow the way this matter has been litigated, I'm just thinking now going forward as this court. Let me just explain my difficulty and maybe you'll allay my fears that this is not going to create a precedent for this court. A party has a matter in another court, let's say the High Court, because there was a matter in the Electoral Court. And then a party then decides to come to this court on direct access. If we allow that kind of litigation in this court, being the apex court, what are the implications of that? And I tried to think, and I thought, could we say it's pending? What about doctrine of least pendants? Maybe not. But it bothers me that you decided not to appeal. And you've already said that each party decided to follow its own route. That's what you said to my brother Madlanga. And I accept that that was your choice. You decided that you want to come on direct access. But I'm worried about how this court, how parties litigate in this court, that this court will now be creating a precedent where it allows parties to, whilst they had another case in the High Court, to come to us on direct access.
Justice Chiki, first and foremost, you would not be allowed to come directly to this court if there were a viable process of appeals available to the party before reaching this court. It's really only where the urgency of the matter is such that the ordinary processes which are available for appeals are not feasible, and so that you can't exhaust that process. So there are protections that this court has against a deluge of direct access, because unless you meet fairly stringent provisions, there is no direct access. And in ours, we have pointed out that we sought direct access because first, it was a matter of extreme urgency. And second, that we did not believe that this court would grant an order which the Electoral Court was not asked to grant and could not have granted on the facts before it, and where no cause of action had been made for that, for the relief we now seek. So that that is the basis upon which we came to court. We thought if we came to court on the basis of an appeal, then there was a distinct risk that this court would simply say, well, I'm afraid we can't we can't postpone the election, or effectively postpone the election, because that's not what was before the court below. You never asked for that. The facts weren't there. We're not going to effectively act as a court of first instance, because there's the anomaly. If we come by way of an appeal, but we're saying to you the facts that we put before you were not before the court below, bearing in mind now that no further postponement is going to assist, things have moved on, and in fact also there's new evidence that we have now. You would say, but you're coming to us as a court of first instance, because you are not coming to us.
Excuse me, I'm trying to understand this matter because it bothers me a lot. Are you saying that the route of coming through direct access was in order to ameliorate the case that was in the Electoral Court?
It was to seek relief we couldn't seek before that court.
And you are saying that we don't have to be concerned that a party who then realizes and wakes up one day and realizes that they did not seek certain relief in the High Court, will then come to us through direct access, not through a direct appeal, and will also not seek to supplement their case in the High Court. You say we should not be concerned about that?
No, Justice Cheeky, because that would be different. If you sought the wrong relief before the court, you can't get the right relief in this court on the basis that that court could have granted the relief that you seek before this court. But our case is that the Electoral Court could not, on the facts that were then in existence, have granted the relief we seek from this court. It was not able to do, would not have been able to do so. And so that particular fear is, I believe, unfounded.
Okay, thank you. On a different point, the Commission has raised a technical, has made a technical submission on the remedy. The Commission says that they did not make any decision. And therefore, because they did not take a decision, to come to this court and seek to review their decision is not, or is misplaced. I don't know if you saw that in their submission.
Yes, but we're not reviewing that decision in this court. I think that's one of the other parties.
Okay, thank you. Thanks.
Mr. Loxton. I'm this side, on your left. Let me write on the backs of my brother Madlanga as well as my sister Chikri and say, there is only one simple issue, whether you satisfy the requirements of direct access or not. And if you don't, you stand and fall. Am I correct? Well, before the Electoral Court, there were the same parties. I'm going to regurgitate what you've argued. There were the same parties, same cause of action, the cause of action being in the functionality or otherwise of the OCNS system. At the heart of your direct access application is still the same substratum that you're complaining about. The pillars of your argument rests on three pillars. It's your direct access and your Electoral Court, why you did not go to Electoral Court, for the reason that you've advanced, or to advance before my sister Chicken, and the dispute of fact. Would it be fair if I say that the defense of issue estoppel as raised by the IEC requires us as a court to exercise a discretion in the event where there is unfairness or prejudice? If we are of the view that no unfairness, no prejudice would be suffered by the Labour Party, then it must fail. Will that be a correct proposition to make?
Justice Matopa, I'd put it slightly differently. The default position is that if you want to preclude a party from approaching another court on a particular matter, you must satisfy the requirements raised judicata, which they haven't. If you want to preclude them on the basis of issue estoppel, you must persuade the court that on the facts of the case, it will not result in unfairness or prejudice to adopt it, and it would be an appropriate approach for the court to take. So the onus is on the Commission to persuade you on those issues.
Excuse me, sorry to interrupt you.
Not at all.
isn't this purely a change of venue? You've just relitigated the same issues, asked for a different relief. Whether it happened at the Electoral Court and happened here, it's a change of venue. Nothing has changed in substance.
Yes, there are a couple of things that have changed. What hasn't changed is that the issue of the functioning of the system hasn't changed. What has changed is you now have new facts in front of you, which the Electoral Court didn't have, which is how many people, the percentage of people who failed to upload, which is a very important fact which they didn't have. The relief sought is different and couldn't have been sought from the Electoral Court.
If I interrupt you, I'm sorry if I'm doing that to you. You know what is my worry is, if the Labour Party suddenly has stumbled upon, so it says, upon facts which motivates it to approach this court on the basis that there are new facts that warrants the intervention of this court directly, but when you strip off all its essentials, what is the crux of this case is the system did or did not work. How you, whatever case, how you dress up your case or clothe it, it takes you home to one point. That system on a particular day did not work. And that's an issue that has been addressed by the Labour Court, by the Electoral Court. And like my brother Madlanga put it to you, it's a question of fact. And that being a finding of fact, the test is clear. Under what circumstances can this court, as an appellate court, interfere with the findings of fact? But this is for the other parties, probably not for you. Now, they'll have to surmount that issue. You are saying yours is different. I don't see it. Explain it to me.
Justice Matopo, I'll see if I can do it, because we're now dealing with issue estoppel. And we can accept that res judicata will not work. So the Commission relies on issue estoppel. And there are two factors which, in my submission, would militate against upholding issue estoppel and precluding a hearing. The first is that the relief now sought couldn't have been sought before the Electoral Court, and therefore you would be precluding a party from getting the relief which it says is the only viable relief that that's available, and you would be condemning it to say you should be satisfied with an outcome which was based on different facts, where you couldn't seek this relief, and a dispute about a 4-day extension. So that's the first thing. The second thing, and I've said this before, so I'm going to bore you with repetition, Justice Matopo, a very salient fact was not placed before the Electoral Court by the Commission, and that is the very significant failure rate of parties to upload. So if we had, for example, gone on appeal, we would have been in this position, would say, but are we now stuck with the findings made by that court on evidence which did not include very important evidence which the Commission didn't provide? And we would say, well, that would give rise to unfairness. So upholding issue estoppel would mean that we would be left with a decision of a court made on imperfect facts, and facts, moreover, not disclosed by the Commission, which seeks to maintain that decision. Who knows what that court might have done if they'd been faced with these facts?
For a judgment in your favor, one has to interrogate the facts. Is that correct?
Certainly, Justice.
And if we are to rehash the facts, there is a finding already on the facts. Now, I just want us on a jurisprudential level, which test do we apply as the apex court when we have to evaluate the facts? Do we take into account what the Electoral Court did, or we approach this case afresh?
If it's an appeal, you would look to see what they find. If it's direct access, you will look at the facts before you now.
So if we look at the facts before us now, we would have to forget what happened at another forum and say we have a newborn baby here, we must deal with this newborn baby.
I wouldn't put it so strongly, Justice.
Well, it is that way.
But you would not be bound by the decisions of that court.
Is this not where the shoe pinches? Because if we are unable to peep through those facts, we have a problem. We cannot approach this case on the basis that it is entirely new, unconnected with anything. We know for a fact that the gravamen of your case is that the system did not work. And for us to make that find that the system did not work, we have to look at the facts. Absent any regard to the facts, we can't come to any decision.
But what we're placing in front of you is the system didn't work, and we can demonstrate it was not fit for purpose. And we can demonstrate that by showing you what a significant number of people who were unable to use it properly, not before the Electoral Court. So it would be a denial of justice to say to us, this court must decide a matter on the basis of facts which excluded a very material fact.
I just want to see it and take me through a judgment writing process where I've heard the argument. I have to sit down and now write the judgment. So I have to write this judgment based on what this application for direct access is concerned, and shut my eyes to the problems that you may have faced and the responses that the IEC may have put up in support of its case. So it will be a judgment as narrowly as possible. Is that how it's supposed to be?
It would be a judgment on the facts before you now, not on the facts before the Electoral Court, and you would not be bound by the decision of the Electoral Court. If we were on appeal, it would be different, but we're not.
Okay, thank you.
Mr. Roxton, there are still more questions for you, and I propose that we take the adjournment just to give you a breather as well.
As your Lordship pleases.
We'll come back at 15 minutes? Okay, 5 to 12. We'll come back at 5 to 12. Yeah.
Mr. Loxton, thank you for your submissions. I wanted to just ask you firstly, as I understand it, the respondents say that it was possible to deliver both the signatures of supporters and candidates physically to the Commission. Why did your party not take advantage of that? If we're assessing reasonableness, if it arrived at 3 o'clock on the day and you were an hour away, why could you not have delivered those documents to the Commission?
Yes, let me answer that. The timetable does not permit, and the regulations do not permit the delivery of supporter signatures in physical form. They're only permitted to be uploaded. The Commission said it decided to act outside of its legal mandate by allowing people to submit signatures by hand. They rely on an email which is an attachment to the answering affidavit. We do not read the email, at least as saying that clearly, and certainly the Labour Party did not understand that it was permitted to do so. It was looking at the legal structure. So the first part was we didn't understand from that email that we were entitled to do that. Second thing is that it is anomalous that the Commission should cite to this court cases which say it is strictly bound to comply with the timetable and the rest, and then say, but we allowed a deviation. I understand, and you will recall that the Commission has also said that they're not entitled to make ad hoc changes. That was an ad hoc change. There's another recent ad hoc change which I understand has happened, which is the extension of the deadline from 5 o'clock to midnight for the delivery of certain information. So, simple point is we didn't understand that we were entitled to do that.
Thank you. I'm also grappling with this 35%, 65% question, and I'm trying to understand the relevance in terms of law. As I understand it, your argument is that your rights essentially to stand for office have been violated in Section 19, that the applicable legal framework is New National Party, which in paragraph 21, Justice Yaqub for the majority said Parliament must ensure that people who are otherwise eligible to vote are able to do so if they want to vote and if they take reasonable steps in pursuit of the right to vote. And we read that to by relevant changes to include the Commission must essentially provide individuals with a reasonable opportunity to be able to realize the requirements for candidature. We have a situation where 65% of people were able to, or unrepresented parties were able to register properly and conform with the requirements, and 35% were unable to. If there were only one party, for instance, that was unable to conform, we are dealing with rights. Usually we would consider it from an individual point of view, but what would the significance of that be for the reasonableness of the system itself?
Yes, there are two ways of testing the system. The one way is to test it by asking, does it function in the manner in which it was designed to function? And there you have the evidence of the Labour Party that there were flaws in it as they experienced that certain things happened. The other way of testing the system is it fit for purpose? In other words, was it a system in which the overwhelming majority of parties were able to comply? So was it designed in such a way that it enabled parties generally to upload the information that they wanted? And we say that if it were one party, so if one party gets excluded, you're looking at that to say, well, obviously that is your that is your Section 19 problem. But if you're looking to see what was the system, was it a reasonable system, which is a word that the Commission uses, then it's not a reasonable system if a significant number are unable to use it for whatever reason. Then you must redesign it. It's like the Banking Act.
Does it not depend on the reasons that people are unable to use it? So, for example, if the system worked perfectly, but various people around the country, different parties were unable to access it because of poor internet connections, would that not affect our assessment of whether or not the system was fit for purpose?
It could, except that you're looking at it from an overall point of view. So, families that are unhappy in different ways, and families that are happy in the same way. But every person might have had a slightly different reason, but the fact is they weren't able to do it. And that's why when I look at the 35, I'd say, but if we'd reversed it, if we'd said 65% couldn't use it, you probably wouldn't hear an argument that it was each one's fault. There would have to be a concession that actually the system is not fit for purpose. So as you go down the scale, you will hit a point where you say the number of people who couldn't upload the information is not sufficiently significant to demonstrate that it was not fit for purpose.
Okay, thank you. My last question is just around remedy. The remedy you request is a drastic one, and as we've heard from the respondents, involves significant cost and repetition of processes. And so I'm just wondering if in your submission there's any alternative remedy that could satisfy you. My understanding, for example, I recall there were parties that came into the election process in the first election in South Africa very late, and they were sticking on the parties onto the ballot papers. I'm not entirely convinced why, from the respondent's side, why expedited processes in that regard would not be possible. But you seem to suggest that it's not possible, and therefore we must go for the most drastic alternative.
So yes, if we knew of a way to avoid the postponement, a way to allow participation through a process of truncated timelines and maybe a recognition of a post facto recognition of efforts made, we would do that. We relied on the IEC's opinion, the Commission's opinion, that it was not possible. But if the Commission were to come to the court to say, we have actually devised a system which allows the election to take place on the proposed dates, we would welcome that, because the point is not the postponement, the point is participation.
Thank you.
All right, there are no further questions for you as it turns out, Mr. Loxton. Thank you.
Thank you very much. I think I preferred the earlier arrangement of 10 minutes free time. Question.
Yeah. Mr. M?
Thank you very much. In the time that I've got, I'm going to address 9 issues. We obviously stand by what we say in the heads of argument and the cases we referred to. I'm going to give an introduction, and I'd like to apologize in advance if it's somewhat sentimental, but it's really what I just want to put to this court is this court's own judgments about the importance and the value of the vote. Then I'm going to deal with the application for direct access, leave to appeal, the question of urgency. But in dealing with that, I'll also deal with this court's jurisdiction within the context of an appeal which has disputes of fact at its heart. I will also deal under the second point with the point taken by my learned friends for the Commission that the approach we've adopted is not proper in terms of Section 96(1) of the Electoral Act. Then I'll deal briefly with the application for leave to leave new evidence on appeal. I have somewhat nervously listened to the question put by Justice Majid to my learned friend, but I hope to answer that question because we do oppose the application for leave to leave new evidence in this appeal. Then we'll deal with what we believe is a fundamental aspect of this case, and that's a misconstruing of, in actual fact, what my client's case is. And the misconstruing is fundamental. And I'll just tell you what it is very briefly. My client does not have any complaint about the election timetable. It's got no complaint about item 9. Its complaint centers on its ability to comply with item 9 in circumstances which are beyond its control. But the Electoral Court proceeded on the basis that my client's complaint related to the timetable and item 9. We then deal with certain of the fundamental decisions, because that's a good way to segue into the Electoral Court's decision. Then we'll deal with the factual disputes. We submit that there are no, with respect, genuine, serious factual disputes. And you don't need to go through the affidavits with the microscope to find that there are no genuine factual disputes. In actual fact, on the respondent's own version, the Commission's own version, there were complaints. On the Commission's own version, the system is not perfect. Now, we're not advocating for a perfect system, but we'll deal with that in due course. Then I would just like to take the opportunity to deal with certain of the submissions made in my learned friends' heads for the Commission, which we believe decontextualize or potentially misconstrue, and I certainly don't submit that there's any animus in that or that it intentionally happened, but we just take a different view on certain of the submissions contained in the Commissioner's heads of argument. And then is the difficult question with respect to on the horns of a dilemma which this court faces, if obviously you find for us, is what now? What must happen? And in that context, I would want to deal specifically, and I intend to deal specifically with the Declaration of Rights that's proposed by the Commission. Now, Section 19 lists the political rights in issue. But Section 19 is certainly not exhaustive of what those political rights entail, because Section 19 doesn't include, but it's regarded as forming part of the political rights, and that is the right to stand for election for political office within the context of being nominated by a political party to do so. So the Section 19 right that we ultimately will submit and hopefully persuade you that lies at the heart of the factual dispute is whether or not the right of my clients, and at the very least 121,000 supporters, that's the supporters list that my client uploaded, that at the very least 121,000 people will be denied an opportunity to vote for the party that they want to, and a party that they've already put their hand on their heart and said they're going to support because they're in the supporters list. And then the exclusion of 470 candidates of my clients who want to stand for my client on the ballot list, their exclusion. So it's two sides of the political right. It's the one to vote for who you want to, and the other one to stand for office. And ultimately whether the frustration of either of those rights, which we submit is presently the status quo, has the effect of rendering the elections unfree and unfair. Now, this application traverses what I recall some years ago, Professor Corder, Professor Murray at UCT telling us, right when this was all new, I'm showing my age, what they called red rights. You had red rights, you had blue rights, you had green rights. The most fundamental and the most important are the red rights. Now, the red right here is the right to vote. It's the right to a political franchise. And His Lordship Justice Sachs, in August versus the Electoral Commission, 25 years ago, said the following, and it applies still today. The vote of each and every citizen is a badge of dignity and of personhood. Quite literally, it says that everybody counts. In a country of great disparities of wealth and power, it declares that whoever we are, whether rich or poor, exalted or disgraced, we all belong to the same democratic South African nation. Our destinies are intertwined in a single interactive polity. Rights may not be limited without justification, and legislation dealing with the franchise must be interpreted in favor of enfranchisement rather than disenfranchisement. So in that regard, and if I can just quickly jump ahead to the relief the question as to what relief would be granted, we would submit an appropriate relief that favors enfranchisement rather than disenfranchisement is the appropriate way to go. This court, in New National Party, also in 1999, held the following. The Constitution takes an important step in the recognition of the importance of the right to exercise the vote by providing that all South African citizens have the right to free, fair and regular elections. It is to be noted that all South African citizens, irrespective of their age, have a right to these elections. The right to vote is of course indispensable to and empty without the right to free and fair elections. The latter gives content and meaning to the former. The right to free and fair elections underlines the importance of the exercise of the right to vote, and the requirement that every election should be fair has implications for the way in which the right to vote can be given more substantive content and legitimately exercised. Now, we submit that the fairness, as I've already indicated, includes the right to stand before election in the upcoming elections. There's unfortunately an unnecessary pejorative tone to the Commission's opposition to this application. And its opposition and the way it's adopted its attitude in opposing this application is somewhat disappointing. And the reason why I say that is the Commission is required to be neutral and independent. It's required with respect. It's a professional litigant. It's a statutory litigant. It's a constitutional litigant. It litigates. And you would expect from somebody who's neutral, importantly a Chapter 9 institution, to place all of the relevant facts before the fact finder when there is a dispute about whether an election is free or fair. And what we have here is a disappointing failure by the Commission to do that. In actual fact, the Commission has done the exact opposite. It's kept its cards very, very close to its chest. And we submit that's dispositive of the dispute of fact. Because when you look at the disputes of fact, it's more about what the Commission doesn't say than what it does say. But I'll deal with that in due course. The other pejorative tone, and I say this in the following sense, the word failure ordinarily has a pejorative negative inference. And the term that's repeatedly used in respect of the affidavits and the heads of argument is that my client failed to comply with item 9 and section 27. It's not a question of failure in the pejorative sense. It's rather a question of an objective inability to comply. So it's not a subjective or negative framed failure, but an objective inability. Now, and that objective inability is, we submit, is that the portal malfunctioned. But it's not that the portal crashed. We don't suggest the portal crashed. We don't claim the portal crashed. We don't claim that the portal wasn't live. But what we do claim, and it's supported by various other parties, even the Commission itself, that on an ad hoc and random basis, the portal lagged, it stalled, it hung, it required users to log out and log in again. And in logging out and logging in again, the information that had been captured was lost. And that, with respect, deals with the factual dispute, which I'm going to come to. Because there is supposedly reports, I say supposedly, there are reports by IT, I think lockdown, and all they tell you is that the portal was live. It was up 100% of the time and it didn't crash. But that's not the complaint. So it's about trying to upload something. And a classic example would be when you try to upload a document that's too big or email a document that's too big. You know that that email is going to sit in your Outlook, in Outbox until it's sent. So it's the same here. It doesn't mean that the system was imperfect. The question is, was the system fit for purpose when it should have been? And that is on the 8th of March, particularly in the afternoon, where you have the evidence from the Commission that thousands of other people were uploading documents. And we'll get to, in due course, the question about, well, if thousands of other people or submissions could be uploaded, why couldn't your client do it? Surely that indicates that the system works. We, with respect, disagree. But when I say to you, I don't want to be sentimental, but what price can you really put, with respect, on the right to vote? Something that mothers lost children for, wives lost their husbands, sisters, people died for this right. The Commission says a postponement is going to cost R500 million. We don't agree. We say on your papers it's going to cost 284 million. It's still a significant number. But let's break it down to the actual identified votes. We know that there are 121,000 supporters of my client. Taking that just short of 300 billion rand to a cost per vote, it's 2,504 rand. If you add the 55,000 supporters for Mr. Loxton's client, the Labour Party, that cost goes down to 1,721 rand and 59 cents. What price do we put on the right to vote? And at a minimum, what does it cost to ensure that South Africans are enfranchised and that they wear their badge of dignity and personhood and that they are not told, quite literally, you don't count? And that's to paraphrase Justice Sachs. Now, within the context of the application for leave to appeal, as we understand it, that application is opposed effectively on two grounds. The first is that this is an issue of fact, and the Constitutional Court doesn't hear fact-based appeals. We disagree. The Constitutional Court, this Court with respect, has already said that's not the absolute rule. And secondly, a reliance on Section 96 of the Electoral Act. This Court, with respect, is statutorily empowered. In actual fact, it's more than empowered. It's obliged. It is the upper court in respect of all constitutional matters. And there is no doubt that what we have here is the infringement of a constitutional right. Or a claimed infringement, you will decide in due course the merits of the case. But that right, with respect, cuts through so many different layers and so many different provisions of our Constitution. If I can just list them for you. They cut through basically the right, the founding principles of our Constitution, Section 1D, universal adult suffrage and multi-party system of democratic government. It cuts through the founding principles, Section 3.2, all citizens are equally entitled to the right, privileges and benefits of citizens. One of the few rights granted in the Constitution to citizens is a right to vote. Section 19, the political rights, which I've already dealt with. In the August judgment of this Constitutional Court, this court held that the following rights are indubitably impacted upon by the right to vote. Equality, Section 9, human dignity, Section 10, privacy, Section 14, freedom of conscious thought, belief and opinion, Section 15, freedom of expression, Section 16, freedom of association, Section 18. it also cuts through the statutory powers of the Commission. And the statutory powers of the Commission are found, have their origin in the Constitution in section 181, which deals with the institution of state institutions, which are there to support our constitutional democracy, one of them being the Commission. Section 119, which places a positive constitutional obligation on the Commission to manage the election and to ensure that they're free and fair. Section 5 of the Electoral Commissions Act, the obligation of the Commission is to manage the elections and to ensure that those elections are free and fair. And Section 20, and this is really where the right, the doorway into the infringement of my client's right comes, within the context of the factual issue we're going to ask you to determine. And that is whether or not the Commission invoked its powers, even considered that it was entitled to invoke its powers under Section 22A, which was to amend the timetable. It had the power to do so. It didn't even consider. I stand corrected, and I'll be embarrassed if I'm corrected, but you can trawl through the affidavits of the Commission. You won't find, all the heads, you won't find a single reference to the Commission actually ever considering Section 20. Not a reference at all. What you will say is, well, we weren't obliged to consider it. Well, that's another question. But did you consider it? Did you consider it and then come to a conclusion that it's not appropriate in this instance? Or that the exercising or the amending of the timetable wouldn't result or wouldn't remedy what's claimed to be unfree and unfair elections? Now, within the context of the... Sorry, one last point, I just missed it. This matter indubitably engages this court's jurisdiction in terms of Section 167(3)(b)(1). Now, on the application for leave to appeal, and if I can take the lead from the debate that your justices had with my learned friend, Mr. Loxton, this is an appeal. It's an appeal on the record that's served before the Electoral Court. Now there's an application for leave to appeal, for leave to introduce two vitally important pieces of evidence that never served before the Electoral Court. The first is the lockdown reports, the IT lockdown reports, the expert evidence about the system's failure. The point was taken before the Electoral Court by my clients in a replying affidavit in the heads of arguments, and we argued. No regard can be had to those reports because, first of all, they are irrelevant. And the reason why they're irrelevant is because they only deal with the system crashing and not being live. That's not my client's complaint, that was already pointed out. So it deals with irrelevant matter. The second is that it was inadmissible because none of those reports were confirmed by any of the authors. So what, the second aspect, which is dealt with now for the first time, is what it's going to cost the elections, to postpone the elections. If I can just quickly point out, there's an amount of R500 million that's claimed, but included in that amount is an amount of approximately 200 million rand, which pertains to voter registration, the costs of having to go through voter registration again. But voter registration, with respect, has got nothing to do with this case. This case deals with Section 27, the submission of candidate lists and supported lists and the payment of the necessary deposit. So of that R500 million, you can take 200 million rand off. But that information was also not before the Electoral Court. And the explanation for that information not being before the Electoral Court, there's no explanation. There's no explanation in the application to need new evidence. As I read the application for leave to need new evidence, it only pertains to the IT reports. But the explanation given for the IT reports is, well, we didn't have time in the urgent circumstances of the Electoral Court proceedings to put up that evidence. The difficulty with that is they never made application before the Electoral Court for the admission of that evidence in terms of the Law of Evidence Amendment Act. To say, listen, this is an urgent application. This is what we've got. We will endeavour to get a confirmatory affidavit. It may not be filed before this, before the the hearing, but we will provide it. Absolute silence. And what is ultimately produced is not simply a confirmatory affidavit. It's a substantive affidavit that deals with the system. But again, it's irrelevant because the expert reports at bundle page 209, what it deals is with the testing as we read it, deals with downloading information from the server. But that's not what it's about. This is about the uploading of information and the speed at which information could be uploaded. So we submit that report, it's inadmissible, and the new evidence is inadmissible, and it's irrelevant. Now, the Electoral Court, with respect, we submit misconstrued my client's case. And the reason why they did that is because, as I've already indicated, they adopted the position that my client's case was about the timetable, and that if we had concerns about the timetable, we should have complained about the timetable. That is not my client's case. My client's case, with respect, I won't say articulately, but it's certainly set out in our heads of argument. And if we can put it in a nutshell, is the following. Act's case, broadly stated, in essence, is not one pertaining to the reasonableness of item 9 per se. This is at page 25, the second bullet point of our heads of argument. Or of lateness. Act's case instead pertains to an objective impossibility that precluded Act from complying with an aspect of Section 27 within the time frame afforded in terms of item 9. More specifically, Act's case is that the decisions of the Commission are irrational and reviewable within the context of item 9 and the statutory powers it has under Section 22. It's also irrational within the context that it was the Commission's platform that malfunctioned. And it's also irrational in the context of the very statutory function, the constitutional reason for the existence of the Commission is to ensure free and fair elections. Now, on the factual position, this court has, in Rail Communications, let me find the reference, we deal with the Rail Commuters Action Group at page 31, paragraph 79, deals with when this court, with respect, is enjoined. It's not a discretion, and I say that with tremendous respect. When this court is enjoined to consider disputes of fact. Rail Commuters dealt with the Bussack judgment, and that this court should, it says that the Bussack judgment must never be read, that this court may never resolve factual disputes. The reasoning in Bussack does not imply that disputes of fact may not be resolved by this court. It states merely that where the only issue in a criminal appeal is dissatisfaction with the factual findings made by the SCA and no other constitutional challenge is raised, no constitutional right is engaged in such a challenge. Where, however, a separate constitutional issue is raised in respect of which there are disputes of fact, those disputes of fact will constitute issues connected with decisions on constitutional matters, as contemplated in terms of Section 167(3)(b) of the Constitution. And we accept that we're not at large to simply ask this court to consider the facts. We accept that. We accept the court's position. We do it absolutely without demur. But what we suggest is that what we submit is that this dispute of fact strikes at the very heart of the constitutional issue. It strikes at various provisions within the Constitution. In Rail Commuters Action Group, page 31, paragraph 80 of our heads, the rule was held not to be immutable. There are exceptions to this rule, and the court held where an applicant seeks constitutional relief and there's a dispute of fact on the papers before the court, the identification of the issues upon which the constitutional matter should be adjudicated constitutes an issue connected with a decision on a constitutional matter, which falls within this court's jurisdiction. In such circumstances, this court is not bound by the facts as determined by the SCA. So, if I can just deal with the factual dispute, such as it is, we submit that there are various objective common cause facts about which there can be no dispute or no serious dispute whatsoever, and those disputes, such as they are certainly not bona fide within the following context. The following objective facts are: My client started on the 21st of February with the uploading of the supporters list. 4 people used the single person's logon user code. They were supported, though, a team of 4 was supported by 20 people who were skilled and had access or used new laptops. A venue was secured in the middle of Sandton for this purpose, and that venue had internet which operated at a high speed and was stable. All the required information for the processing of the submission was available. My client had successfully uploaded more than 121,000 supporters' names and signatures. It had paid the deposit. So for the Commission to say that my client didn't understand how the system worked is, with respect, belied by the facts. It struggled. I'm not denying that. And there were these difficulties, but it still managed to put up its supporters list. It had to pay the deposit. That my client experienced difficulties and delays is also not in dispute. The fact that it phoned the IT call center to raise these complaints is not in dispute. The fact that the best the IT call center could do to tell my client was to log on and log off again is not in dispute. And the fact that logging on and logging off meant that you lost all of your information, which had been uploaded, is not in dispute. It's also not in dispute that all my client required, and this is on the Commission's version, to upload its candidate list was an hour or 2. It's not in dispute that my client had an hour or 2. It started at 14:53 on the 8th with the uploading of the candidate list. So it's not in dispute that there were various political parties that raised the exact same complaints as my client did about the platform glitching and hanging and about it stalling. And none of those complaints relate to whether the system was live or not, or whether it crashed. They all relate to the same thing, the glitching, the malfunctioning of these difficulties. And we now have an acceptance from the Commission. Well, we deny that the system failed. Despite us acknowledging that other people complained, and we refer to those particular positions, it adopts a contradictory position in the affidavits filed before the Electoral Commission in the Labour Party Act. We had admitted other parties had complained. So what we have here is a dispute of fact that, with respect, cannot survive even the most superficial scrutiny, because the dispute is resolved solely on what the Commission acknowledges and what is common course. And it begs the question, if my client had been able to upload 121,000 supporter lists and names, why was it unable to upload, in only the hour or 2 it needed, the names of its full candidate list? Now, there's a reference in the papers to 2 other political parties that managed to do it at the last minute. But there's nowhere, and this is where the Commission isn't candid. We don't know if we're comparing apples with apples. We don't know how many other candidates were required to be uploaded for the other political parties. It may have been 1, it may have been 2, not 540 odd, as my client had. And as for the second of the parties, it was the African Independent Congress, the Commission actually helped. So, with respect, we submit that there's nothing that can be done. Lastly, I just want to deal with the declaratory relief. The declaratory relief doesn't remedy the infringement of a right. All it does is pat my client on the back and say, sorry for you, life's not fair. But the elections are supposed to be free and fair. And we submit, as they stand at the moment, they're not free and fair. Thank you.
So what kind of order do you want us to grant if we find in your client's favor?
It's very difficult, Deputy Chief Justice Meyer, because my client's case, and this was a difficulty with respect before the Electoral Court, my client's case got contaminated by the other cases. My client's case is quite simply, you say we need an hour or 2, give us an hour or 2. That's all we need. We don't need the whole process to be opened. We don't need anybody to go back in time. Just give us the hour or 2 you say it would take us to upload. That's the relief we would receive. Obviously, the postponement of the election is the most drastic relief. And I don't want to be free with taxpayers' money. But if that is what it costs to give recognition for a right that people gave their lives for, then that's what it costs. So we would obviously ask for a limited relief. Just give us access. If it's impossible to give us access and that results in the postponement, then I'm certainly not flippant. I don't want to say so be it, but if that's what happens, then that's what happens. But the primary result is, Chief Justice Meyer, Deputy Chief Justice Meyer, is the non-postponement of the elections and the non-granting of my client's right, some relief, does not render what is already an unfree and unfair election free and fair with respect. Because it's already unfair and unfair. We are asking here, we come here to this court, and we're asking for relief to assist us to allow supporters, voices to be heard, and to allow 470 people to be on the ballot list. So it's a very difficult question. That's the horns of the dilemma. But if it needs to be postponed, it must be postponed. There's sufficient time with respect because it's only the 19th of April. 19th of August, I believe, is the last date for the election. You read, and His Lordship, Justice Majid dealt with it, albeit in a throwaway comment where he dealt with the conjecture. We know nothing about what the other parties, other political parties' inconveniences or their cost to them by postponement of the election. We don't know anything. None of them have come and told you. It's with respect not for the Commission to speak on their behalf, but what we do know is that they could have come and told you within the context of the Labour Party's application, because they were cited in that proceeding. But nobody's come forward. So what you have here is absolutely no evidence other than conjecture and speculation that other parties will somehow be inconvenienced or will suffer financially or don't have resources that can survive a postponement. There's with respect no evidence before this court.
Mr. Am, I am still on the relief sought. The IEC said that it cannot just open for one party.
Yes.
If it opens, everyone would have to come in. And that's why then one ends up with a postponement. What do you say to that?
It's a very difficult question that you ask, and one that myself and my juniors have wrestled with. The question is, my client has exhausted its rights to be able to participate. It raised an objection. It went to the Electoral Court. It lost 3-2 in the Electoral Court. It comes to this court. It has taken all of the steps it requires to protect its rights. Other parties don't appear to have done that. We don't know the reasons why they haven't done that. But all we know is that my client is with respect, asking for an hour or two. Whether this court decides that fairness dictates that then it must be opened up to everybody, just the Section 27 process, then that's what fairness dictates. But my client, with respect, can't be non-suited in a sense, and I say non-suited because the court may decide in its wisdom to not reopen because then they have to reopen for everybody. But why should my client be prejudiced because the other parties who are similarly situated never exercised their rights, never came to court and complained? So it's a very difficult question you ask you, and it's really a policy-laden answer. But all I can say is my client has exercised its rights. It shouldn't be prejudiced because other parties haven't, with respect.
Thank you. You criticize the IEC for having told us the cost implication of the postponement of the election.
Yes.
But surely, and we say that that is something that was not before the Electoral Court.
No.
It was not before the Electoral Court because that issue was not raised at that level. It's raised before us by one of the parties. And because of that, the IEC has a duty to then tell us what the implications of a postponement. We as a court, we need to know that information.
Yes. Justice McLaughlin, I think there are two answers to your question. The IEC was quite clear in its affidavits before the Electoral Court that if the relief sought is granted, they cannot guarantee free and fair elections. on the 29th. So they knew even then, before the Electoral Court, that there was a risk that a postponement may ultimately eventuate. It was put to my learned friend, I think by, trying to remember, one of the justices in the Electoral Court. It may have even been Justice Adams. What happens if we give the relief? My learned friend says, well, then what we will have to do is ask the President to postpone. So it's always been an issue. But there's no explanation as to why that evidence, with respect, despite it being there, wasn't put before the Electoral Court. But our complaint, sorry, maybe I didn't make it clear. Our complaint so much about the new evidence doesn't directly impact on the cost. We obviously accept there's a cost. We obviously accept it's going to be very expensive to postpone the elections. Our real complaint is about making out a case that you never made in the Electoral Court when you were told you hadn't made a case in the application here. And what's important, sorry, with the report, as they said in the application to lead evidence, that we couldn't get this in the time available. But as we point out in our heads, they asked for the report in the context of this application, and they got it the next day.
Okay, we're moving to the report. Okay,
yes.
Let's put that
but
just
hope they
for
asked your
clarity,
question.
from my understanding,
Yes.
you, in your papers, you refer to direct access,
Yes.
and at some stage you say direct appeal. Tell us exactly what I'm seeking. You also refer, you then deal with the judgment of the Electoral Court. I would believe that would be an application for direct appeal, not direct access. But I don't want to make the assumption if you are maybe applying in the alternative for what.
We put it inarticulately, and I apologize. We did it under tremendous pressure. You will see, I think, the application to this court, I think, went out a day or two after the Electoral Court's decision was handed up. What we're asking this court, what we're telling this court, is the Electoral Court got it wrong.
So that's direct appeal, no direct access.
Yes, we don't have time to go to the Constitutional Court. Please, can you help us? In these urgent circumstances, we've got an election on the 29th.
No, that's fine then.
So, sorry, it was inarticulately, but that's what we want. We want some assistance from the court.
Thank you. You said that you were registered, your party was, okay, the applicant, no? It did not say your party. The applicant was registered on the 21st of February.
That's when it first obtained access to the system, the 21st of February.
You see, there seems to be some confusion about the timing of the payment. It seems as if it waited until made the payment of the deposit before uploading the candidates. And my understanding from the IEC's perspective is that all that is required is for the party to get the reference, payment reference, then do the upload, then pay. So why was that not done in the case of the applicant?
That's a very good question. My client says, if I can just go back, and it's not disputed, that the parties were strongly advised to use the system, not to make hand deliveries. And we already know that the submission of the supporter lists had to happen through the system. My client understood the position, and its understanding is not challenged. The correctness of the understanding is. My client's understanding was, well, before we can go to uploading the candidates, we need the system to tell us what is owed and what deposit must be paid. And in actual fact, if you have a look at one of the flow charts, and we refer to it in our heads, one of the flow charts from the manual from the website shows you that you pay the deposit before you move on to the candidate submission process. So if the commission understands it one way, its documents say it another way, and we understand it the way we did, then it begs whether the system was an appropriate system. So that's the answer. That's what we understood, that's what their document says. Albeit I don't for a moment suggest, because it's not in the papers, that when we did that, we looked at the document. I'm certainly don't want to, I'm not being opportunistic, but the document confirms what we understood the position to be.
Now, having realized that you had problems, you said this started around 14:53 or 3 o'clock, and you were not They are not far from the offices of the IEC, about 40 kilometers away. Why not make a physical submission of the...
If I can answer that on 3 levels. The first is, as I've already indicated, and it's not in dispute, the parties were strongly advised to use the system. That's the first level. The second level is that the system, when it worked, it was quick. That's not dispute. We say that in the affidavit. When it wasn't glitching, it was quick. So the third level is now my client sits on this horns of a dilemma. It knows at any time the system can be fully functional and everything can go through, or does it stop doing what it's doing, pack everything up, get in a car and drive to Centurion? Ultimately, that's what it did. It packed everything up and drove through to Centurion. It did it a bit late. I think they say they left in the affidavits at 4:20, and they got there after 5. But that's what they did. But it's the horns of a dilemma. Do you do this or do you do that? Knowing that you might get stuck in traffic on the way there, or is the system going to suddenly function perfectly or smoothly? Let me say smoothly. It's that horns of a dilemma. I certainly don't think the criticism that my client could have submitted it physically is something that can really non-suit my client, because it did what it could.
Thank you, sir.
Thank you.
Mr. M,
Justice Majid.
I want to understand why you say there's no dispute of fact here. I thought the central issue was what? Did OCNS work or not? And if it didn't work, it wasn't fit for purpose, was that the cause for this non-compliance? Isn't that a central issue?
No, that's a central issue. But the question is, a dispute is raised about that issue. The answer, how you answer that question is twofold. And they indicate processes. Is it a serious and genuine dispute? And in determining whether it's a serious or genuine dispute, you analyze the dispute and you see what the parties say regarding the dispute. Now, there's a dispute in inverted commas, but it's not genuine. And the reason why it's not genuine is because there's objective common cause evidence about the difficulties my client and other parties experience. That's objective, it's not disputed. So we know that there were complaints by various parties about the functionality. We know that. What we do know is what we don't know, sounding like Donald Rumsfeld. He said, we know what we know what we don't know, and we don't know what we don't know. But what we don't know is what parties complained, like my client complained about glitches, to the hotline. And which of those parties are now part of the 35% who've been disenfranchised because of the system? We don't know. The only custodian of that information is the Commission.
Let me just stop you there and make a quick correction, which is very, very important for the narrative in this case. It's not 35% of the electorate.
No, absolutely.
35% of unrepresented parties.
I beg your pardon?
35% of unrepresented.
Yes. Sorry. I'm talking about if you want to try and put the same apples in the same basket. We don't know what the position of those people who complained. We don't even know who they are. We're not even told. And we're not even told what the outcome of the complaint was in the context of whether they were precluded or not. So we don't know what we don't know, and the only person who could have told us is the Commission.
All right, let's just switch off the microphone like this. Let's interrogate this answer. How many sub-users did the ACT have?
We had 1 registered sub-users and 4 people using that license, or using that access.
Okay, the short answer is 1. Did it upload manually or in bulk?
It uploaded manually. It was for the supporters list.
When did it pay its deposit and upload its signature, supporter signature list?
It struggled to pay its deposit on the morning. It ultimately paid the deposit sometime in the early afternoon, and it started at 14:53 with the uploading of its supporters list.
Short answer is on the 8th of March. Now, so on the 8th of March, the system works well enough for you to do all of those things, pay the deposit and upload all those thousands of supporter signatures. So how come what's good for the goose isn't good for the gander. How come suddenly now we're in a different ballpark with the candidate list on the same day, same party?
No, with respect, Justice Majid, my client commenced the supporter list process on the 21st. It had a team of 20 people there. It hired a venue. 4 of the people used the access code. There was 1 access code, 4 people used it. It completed the supporter submission list on the 6th of March, except for, I think, one of the provinces. It then completed that outstanding province. It then attempted to pay the deposit because it believed the deposit had to be paid before you go on to the next step. So with respect, whilst the complaint is ultimately rested on the inability of the system to function, my client does say in the affidavits that its ability to upload the supporter lists and the deposit list was extremely frustrating for the same reasons. So it's not that, with respect, my client left this till the last minute on the 8th.
Now, when one looks at fairness and you talk about objective impossibility, those are self-evidently objective assessments. Now, what about all the vast majority of represented parties who are able to do all these things by the 8th of March? What about the 65% of unrepresented parties who are able to do so? If you talk about objectiveness, surely we can't be bound by subjective experience of your client and others.
If I can just deal with the last point first, just to clarify, and we disagree with great respect, classifying my client's experience as a subjective experience. It's an objective experience. As an objective fact, the system glitched, it hung, it stalled, it kicked users out, it reverted to the home page. That's an objective fact because there is no evidence from the Commission, admissible or otherwise, that suggests otherwise. We also have as an objective fact the complaints that were made. So I say this with great respect, we don't agree with the classification of my client's difficulties as being subjective. They were objective. Now, to go to the position of the 65% that managed to do it, if I can answer that question by looking at the other side of the coin, my client had successfully done everything it needed to do. The Commission says it needed an hour or 2 to deal with the last process. It had an hour or 2. So to say my clients didn't know how the system works is belied by the facts because it got to that part. It's like driving to Cape Town. It got all the way to Worcester and then suddenly the car doesn't work. That doesn't mean my client now doesn't know how to drive, doesn't know how to use a car. My client knew how the system worked. It was frustrated in the use of the system. And when it really push came to shove, and we have all these thousands of people attempting to access and download and submit candidate lists and supporter lists in the afternoon, the system simply wasn't fit for purpose. But sorry, if I can just answer one thing. In the context of you asking, did my client submit the supporter list manually? It did. But what you do have, with respect, is the evidence, the video footage of the land party, which shows the system failing. And the Commission's answer to that is yes, but they were manually uploaded. But if if the information you're uploading manually is a lot more limited and less burdensome than a bulk upload, if the system wasn't even tolerating manual uploads, what would it have done with bulk uploads? Because we know in the affidavits we're told that bulk uploads you needed to split files and download them separately. Sorry, I forgot to deal with your point and your question around the manual uploads.
See, on the prospectus of all the evidence, this is what we have. We have a party that waits until the last day to do what is absolutely essential, and it's a new party, it's keen to participate in these important elections. And I've said this before to Mr. Loxton, so you will hear it again because you're a different party. Let me hear what your answer is. So they wait till the last day. They don't engage multiple users like others, for example, the Patriotic Alliance, also a new party did. They don't do bulk uploads like many others have done, and which is the most efficient way of doing it. They use manual uploads. And then you ask the court to come to your assistance where the overwhelming majority of other parties were able to do so. Do you think that's fair?
I think with respect to say just because other people did it and my client didn't.
Sorry, can I just interrupt you? There are two judgments of this court. And remember, we are bound by them. It's Liberal Party and Inkatha Freedom Party. Both those cases say this. It says for elections to be credible and for the commission to have integrity, we must have two things. We must have rigid adherence to the rules. Everybody knows what the rules are. So if you allow anybody to stray from the rules and say, listen, come, just help me out, it can't work like that. So there has to be a rigorous adherence, but also there has to be even-handedness. For elections must not only be free and fair, they must be seen to be free and fair. It's much like justice. And so how do you justify accommodating these parties when the overwhelming majority has done what they had to do? And the election timetable was never under any challenge. We didn't challenge item 9, we didn't challenge the regulations under which it was passed. So on what basis is it fair to do this for you and not for others?
The premise of the question with respect is that the majority rules. The question of fairness.
It's what Liberal Party and Inkatha Party says, even-handedness and rigid adherence.
Yes. Well, both of those judgments are, with respect, distinguishable on the facts. They both deal with parties that were just late, who endeavoured to do what they were required to do after the fact. That's not the case here. Secondly, the fact that 66 or 65% of the people did it means that there are 35% of the people who were unable to do it. And it certainly can't be, with respect, fair to adopt it just, well, the majority did it, that's fine. Because that's with respect not fair, because my client's inability to do it was because of reasons, an objective impossibility. Not because they left it for the last minute. With respect, we also take issue with them. They started on the 21st. They set in place, they took various steps, they incurred money, they hired venues to do what they needed to do from the 21st. So they never left it with respect to the last minute. But if I can just deal with the last minute argument, in our heads we refer to the new National Party, the National People's Party case. Because that case deals squarely with somebody who left it to the last minute and a claim of tardiness. My client wasn't tardy with respect, it just wasn't tardy. It had the time to do what it needed to do if the system worked. But in the National People's Party case, the contention, namely that the applicant's woes were self-inflicted by reason of it not acting in good time, is imprudent and simply lacks respect for the applicant's rights. It's not capable of being sustained. The fact of the matter is that the timetable had been established and requirements can be fulfilled at any time within the confinements of that timetable. That a particular party or person chose to comply therewith at the last minute does not detract from the right to participate in the election or exercising the right to do so. So to suggest that the applicant only has himself to blame and that the chairman would not have had to rush if the requirements had been complied with long before is not helpful. The applicant was entitled to submit the documents at any time before 5 o'clock on the 25th of March 2011. My client needed an hour or two on the Commission's version. It had an hour or two. It couldn't do it.
Yeah, and that case, which in any event doesn't bind us, what that case doesn't deal with is the question of the methods that you use. You use the most inefficient methods at the last minute. That is what is the distinguishing factor.
Mike, if I can just answer that about the most inefficient method. My client says its understanding was that it had to pay the deposit first and that the candidate submission list had to be done manually. That's its understanding.
Yes, thank you.
Mr. Am?
Yes.
Earlier in your submissions, when you were taking us through what your case is all about, you said that you are not attacking the timetable. Yet, you are saying that we must give you an extension of 2 hours or so, are you then not asking us to extend the timetable when you ask for that remedy?
Well, the basis upon which we come to court, Justice Cheek, is the following. Due to an objective impossibility, we never met the item 9 deadline. The Commission had it expressly within its power to exercise a right given to it under Section 20 to amend the election timetable. We know from the affidavits that it had previously, at the outset, amended the timetable. That's our complaint, is that the Commission did not exercise, did not even consider the right it had to extend. So it's within that context, the Electoral Court could have granted any order. It was at large to grant any order that would remedy that. It's not constrained, and this court, we submit, is also at large to grant any order that ensures a free and fair election.
Was the timetable reasonable?
The timetable per se is reasonable. My client's ability to meet the timetable became objectively impossible for reasons beyond its control.
Another issue that confuses me is that in your submissions and during your debate with Justice Majid, you said that the system was quick. And I don't know whether you even said it was good, but you said it was quick.
I think the word is used, it was swift and speedy.
Swift, yes. But you say it was not fit for purpose.
Yes.
I just find that a contradiction.
No, it's not with respect. My client's case is that the system, on an ad hoc, random basis, simply started to hang, or kicked you out, or refused to identify ID numbers, or reverted to the home page, randomly. When that wasn't working, when it wasn't randomly malfunctioning, it worked. It worked speedily, but the fact is it had these glitches. That's the very nature of a glitch.
Do we know what caused those glitches? Could it be your internet activity? As we're sitting in this court now, do we know if your internet was stable?
You are told, with respect, Justice Chiki, and the Electoral Court was told, my client hired a venue in the Sandton CBD that had secure internet access. It had up-to-date computers. The internet was speedy and reliable and stable, and that the people that it had selected to do this task were hand-selected by the deponent and had the necessary skills. There is no evidence before you contradicting any of that.
No. I think my question was directed at the time.
Yes.
The time in question, because as you know, it might be stable in the morning, but at some stage, it would be unstable and all of that. I don't have evidence.
No,
I'm speculating, and I'm asking you because I'm avoiding speculating.
I'm sorry for interrupting you, Justice. The evidence is that the glitching and hanging and stalling wasn't just confined to the 8th. It's something that started earlier. And that's why I took my client from the 21st to the 6th to deal with the submissions. So it was a repeating problem. And it's a problem that was experienced. The glitching, the stalling was all experienced by other parties. And it's common cause that they complain about the glitching. It's bizarre that they all use the same language. But the complaints are not limited to my client. So the probabilities is that there must be, and it's not just an inference with respect, the probabilities are that the problem must be on the side of the portal if everybody has the same complaint.
Mr. M, thank you for your submissions. I first wanted to ask you, you've gone at pains to argue that there's no dispute of fact. I think we may find that there is a dispute of fact, and then generally the Plascon evidence rule would apply. And I would just like to hear your submissions. There have been cases which have argued that in certain circumstances the Plascon evidence rule is not fit for purpose. I referenced the case of Mahala versus Nkombombini, which dealt with a burial that was to take place the next day. And the judge in that case held that in favor of the applicants. and essentially ruled that the Plascon evidence rule was not helpful. And in academic commentary, Alan Dobson has said in the annual survey of 2006, implicit in the court's approach is that the recognition that the rule may sometimes cause hardship for the applicant, and perhaps is maybe not even constitutional in certain circumstances. We are faced here with a situation of urgency of the hearing in front of the Electoral Court, where there's, as I understand it, generally has to take place on the papers rather than in relation to oral evidence being heard. In those circumstances, I would like to hear your submissions as to whether or not these circumstances may call for a relaxation of the Plascon evidence rule.
We submit absolutely, and we make the submission on 3 grounds. The starting point is what His Lordship Justice Harms said in the National Director of Public Prosecutions versus Zuma case. His Lordship Justice Harms proceeds on the following basis. Motion proceedings, unless concerned with interim fact, are all about the resolution of legal issues based on common cause facts, unless the circumstances are special. They cannot be used to resolve factual issues because they are not entirely to determine probabilities. We submit that the circumstances here are inherently special. And the reason what makes them special is the following. My client was obliged to go on motion to the Electoral Court. Okay? It finds itself in a disadvantageous position because usually when you're dealing with statutory bodies in a, let's take a tender environment, and you follow a Rule 53 process, you call for the record, you get all the information that you need, you're then entitled to supplement your notice of motion and your founding affidavit, and that's your case. My client didn't have a right to what the Commission knew and what facts the Commission had. Yeah, it wasn't entitled to call for that. So all it can do is go to court on the little bit it has. It's not in control of the system. It's not possessing the information of who was able to do it and why, and how do you compare apples with apples. Because the only way you can compare another party with my client is to say, well, they had 121,000 supporters and 530 odd nominees. That's the only way. But the only custodian of that information is the Commission. So these are specifically special or exceptional circumstances, particularly of the type that His Lordship Justice Harms contemplated. But my third submission goes right back to the start of when I dealt with the dicta of His Lordship Justice Sachs. He says things must be interpreted in favour of enfranchisement rather than disenfranchisement. We're dealing with constitutional rights here, the right to vote. It's fundamental. And for my client to fail on a Plascon Evans test, when it's disadvantaged because it doesn't have the information, and it's disadvantaged because the Commission doesn't put up the information, is with respect, applying the test in that circumstances is with respect unconstitutional. Because my client hasn't been afforded the right to a fair hearing.
Thank you for your submissions in that regard. A second issue that I worry is that at what point can we conclude that where there was no reasonable opportunity to comply with the election timetable? So I think we can have two extremes. If no party managed to succeed, it would clearly not, there would be no reasonable opportunity. If there was only one party that didn't succeed, you would perhaps think that the system was reasonably capable. And here we've got a strange system of situation where 65% of unrepresented parties succeeded and 35% didn't. I'd be interested to hear in your submissions of how we examine reasonableness in that in those circumstances.
This is a rephrasing of a question you put to my learned friend Mr. Loxton. Myself, my dude, was debated it at the break. It's a very difficult question, but ultimately it's a question that can't be answered in a factual vacuum with respect. It can't be answered in principle, because where do you draw the line? It's got to be a fact-bound inquiry and an inquiry that's determined by the facts. It's impossible to say with respect. I submit. It may be that one person being precluded for issues entirely beyond their control, absolutely entirely beyond their control. Namely that the Commission had, let's take an example, had given the incorrect access code. That's a fact-bound inquiry, so it's very difficult, if not impossible, with respect to answer your question in a factual vacuum.
Okay, my last question relates to relief. I wasn't entirely clear from you and in your discussion with my sister exactly where you were going with that. My understanding was that you had proposed relief that was not the most drastic version of the relief required. And so I'm wondering, is there a way to grant you an order, if we find in your favor, that would have relevance to your client, which would enable their participation without postponing the election?
Well, what we would certainly eschew is any declaratory relief. What we would certainly not want is declaratory relief. Sorry, you didn't make it, better luck next time, because that's ultimately what it would be. But as to what relief is to be granted and whether it's competent, the only person who can tell you with respect is the Commission. All we know is that the Commission tells us that for us to do what we need to do, assuming a perfect or a system that operates fit for purpose, an hour or two. Whether they can fill it in or not, we don't know. We're not in possession of that information. And that's why I'm sorry, I can only give you a vague answer. But we would certainly want to participate in the election.
Do you understand?
We'll take the lunch adjournment, but an abbreviated lunch for 45 minutes. We'll come back at 2 o'clock. We have finished with you, Mr.
Am I finished?
Yes.
So I can enjoy lunch.
You can enjoy your lunch.
Thank you very much.
Good day once more. Let us be ready. Good day. Let us be ready. Thank you.
It's your turn.
Afternoon, Justices. Yes. Yes, Justices, I propose to deal with 3 topics.
Carry on.
I propose to deal with 3 topics for our submissions. The first one would deal with the proper interpretation of Section 27, considering the text, context, and the purpose, and in line. I'm saying we tend to deal with the first point is 27, consideration of interpretation in line with common law principles of interpretation, and in line with Section 39 of the Constitution and other jurisprudences that are developed by this court. I'll then deal with the second question of a proper interpretation of Section 19, specifically also on the jurisprudence insofar as interpretation of the rights that are concerned. The third point that I then love to deal with probably at length is to demonstrate and persuade the justices that there are actually no material disputes of facts. It's only the question of law that ought to be determined by the court. So, in substance, first issue and the second issue, it will then encompass the so-called jurisdiction for this court to hear this matter in terms of Section 167. But before I proceed with my key important issues, I just highlighted to say that there's one issue that has been arising. It's that of opening of the floodgates in event that the court was to be with us in terms of giving us an opportunity to participate in elections. That question then find an answer. It's important for me to do with it. If justices would have a regard to Section 28 of the Electoral Act, purely from literal interpretation point of view, it's couched in a peremptory terms to say that IEC has got a mandate. Actually, even that one able to comply, then it comes a perimeter upon IEC to identify all those issues, identify why the parties do not comply and afford us an opportunity to comply. So it deals with that aspect of saying if was the issue for whether the election should be postponed or not postponed. That's another thing. So Justice, I humbly request that as we retire, consider 28 and in light of the discussions that are arising out of this country, consider Section 28 of the Electoral Act. The second preliminary issue that I just want to clarify and perhaps to outline properly. Justice, is my earlier life before I was called to the bar. I was in IT and computer, so I understand that language quite well. So I'll just have to demonstrate graphically how the system works. and to demonstrate that it's from a graphic point of view, from a sequence point of view. So how the system works, so ordinarily, in terms of the IEC, in order for one to qualify to contest for
are you giving evidence from the bar now, Mr. Rabayiti?
No, I just wanted to just outline this. IEC has covered the thing. I just want the system,
in
how
the
it works. In the IEC's answering affidavit, they dealt with the system.
Right.
So it's important for one, because what becomes crucial issue in the system is to understand the system, to say the starting point. The starting point, it's manual submissions of the members of the organization. You punch the IDs manually. Then the system will then automatically generate to check whether you qualify or don't qualify. It kicks you out. That's a manual submission, the starting point. Then once then it's done, you will then move to the second scenario where you do what you call a bulk submission in a form of a thing, in a form of an Excel. So it's very important that you understand the more you outload, then the system then it will then generate automatic. So it's not something at all. So once you punch the IDs, then it verifies that either they will be kicked out, others. I'm just doing an overview from a general point of view, just to understand. So if then the IDs then it kicks you out, others will it will admit, others will kick them out. Once those are then verified, then it moves to the second stage, which then we call it a bulk submission. So those that are verified, then you then populate it in what you call a spreadsheet or Excel. Then you upload it in the form, the second stage. Once then you done the second stage, then it then give you what you call that invoice, the payment, to say that, all right, I see that you qualify. Therefore, it generates the payment. So the payment, then you then do the payment. After submission of payment, that's when you can upload the last stage, your contestant, where they're going to. So in the olden days, just to remember, we have a National Assembly, we have a Provincial Assembly, then Provincial Legislature, and we have Provincial Council, Council of Provincial Provinces. So historically it should be called like that, but now we call it regions. For the purpose of the new language, it's called regions. So depending, so if for instance, you want to contest national, of course it says that you need to have 13,000 signatories. So if then you'd say one region, for you to contest, let's say, so the NCOPs or the provinces are regarded as regions for the purpose of elections. So if you qualify for the Free State, let's say for instance, your 4,000 signatories, then automatically it will tell you qualify. So it's in stages, just like that. So that's how the outgroup of the system it is. So that's how the outgroup of the system it is. So I'll then demonstrate in the facts that are unique and peculiar to us as ASD, that we complied, strictly and substantial compliant within the definition and the meaning of Section 27, when you consider it from text, context, and purpose point of view. I'll demonstrate. Now, just let's then deal with the issues of the facts. Now, if then I was to take you to the facts that are unique to us as ASD, it's a common cause that we didn't start. We started as early as the 28th. Even IEC concede as early as the 28th of February 2024. Uploading of the signatories, of course, it didn't take quite a long. It took a couple of days for us to upload the signatories. So insofar as what 27 requires, so when you consider 27 purely from a linguistic point of view, we qualified in terms of uploading of the signatories of our supporters. That's number one. Number two, then the payment was then generated before before it kicks it out. So on the second scenario, also from literal from literal point of view, we qualified within the Section 27 what 27 says. Now, what becomes crucial, where I'm saying it's a mountain to climb, but it's worth persuading the court that you agree with us. So when it then came to our candidates, we submitted. I can refer to the IECs because we then, when it came to our candidates that we participated, we uploaded recreative law. Unfortunately, we didn't, in the proper language of opponents, it's we didn't click that finish button. That's the crisis that as we're sitting in the portal. So from a manual point, it's like if you were to submit, if you were to rush it, if you were to have been submitting our things at IEC physically, one would say that we walk in, but we're in between the gate and the door. So on that supposition, I make a proposition that it's a common cause fact. So on a proper compliance of Section 27, we did comply. We were just unfortunate because we were sitting in portal, we didn't click that finish button. So those are the facts that I wanted to canvass to say that from a factual point of view, we complied. Now, I want first to deal with the first point of Section 27 of the proper interpretation, because my learned colleagues had advanced certain factual issues at length. The question of law was not dealt with. Justice, in our heads of argument, we quoted a case of cool ideas in this court. We decided that interpretation of a statute, you need to consider the text at first, consider the purpose, text within the context and the purpose, and most importantly, consistent with the Constitution. What it really says is, when you're looking at Section 27, of course, from a textual point of view, it's quite clear. It says that you must submit and comply. Within the context, when you look at it holistically, between context when you look at 27 and 28, is we need to comply. Even if you didn't comply, it becomes incumbent upon the IEC to notify us that we didn't comply. So when we look at 27 from the context point of view, it's that it cannot be read in isolation. It has to be read within 28. So it's on that basis I'm saying that from a contextual point of view that we complied. I'm simply saying this on the narration of the facts that I've referred to. So if you were to consider our facts uniquely, they fall within the parameters and the definition of Section 27. And then also the whole purpose of Section 27 is to afford us an opportunity to be able to participate in the elections. So insofar as 27 is concerned, Justice, the point that I want to make is, I've demonstrated that we paid 350,000 that was required. We submitted the signatories. Our candidates, even the report there's where they say in the Free State we qualify. So our facts fall within the ambit of Section 27. Safe to say, whether we're sitting there we're in between the gate or the door, but we are in. So it falls within the parameter of Section 27. So also from a purposive point, from contextual point of view, we're saying, even if, let's say, IEC says, all right, we cannot condone your non-compliance as the defense, or they don't want to tamper with the timelines. But 28, it's couched in the deliberate choice of the language that we check. It's couched in the parameter to say they must inform us. So on that basis, on that basis, I make a submissions that we did comply. Justice, of course, there's a case that actually the most recent case that appeared before you in Africathe versus Borako Marine Campus, but of course that case was dealing more in the context of prescription and apparent prescription on several authority. But what becomes important in Makati, insofar as also interpretation, the jurisprudence that this court indicated in Makati, was that if there's an infringement of any rights protected in the Constitution, in this instance, we're talking about Section 9, what Makati said, it becomes incumbent to interpret legislation within the prison of time. It takes the of the cases, there's Gundai and others that came before. So all I'm just saying, Justice, I'm saying, even if we were to consider it, it then becomes incumbent within the jurisprudence of Makati to say, all right, we didn't comply, but it becomes incumbent to consider, because the right at stake, it's Section 19, so it's important for one to consider 27 within the prisms of the Constitution. That's another point that I just want to make. I don't want to dwell a lot in terms of interpretations of my learned colleagues have dealt with it. Now, if then I then move to our second point, that of Section 19. Section 19 becomes a very, very important right. Understand the history of our country. The thrusters of the Constitution were quite clear why there's a need. That's why you then consider, when you consider the founding provisions of our Constitution, adult suffrage is quite clear. What this court said in the first, one of the earliest jurisprudence in the case of State versus Zuma, then was followed by Makwanyani, which then dealt with the proper interpretation of the Provisional Bill of Rights. It provided what we call a two-state approach when you're dealing with the Provisional Bill of Rights. As an applicant, I need to demonstrate that one's right has been infringed. That's the first stage. If the court is then persuaded, and then it comes upon the IEC to demonstrate that that limitation is reasonable and justifiable in an open and democratic society. That's what the second phase comes upon the proportionality test and the likes. But what becomes crucial, Constitutional Court said, what becomes crucial, this court said, you need to consider it purposively and generously. Those are the two important aspects that you need to consider. So it says that what is the most important purpose of Section 19? It says that consider the purpose of that right that it needed to protect, why it was enacted, and consider the history of this country. It's quite clear, it's quite evident that majority of South African citizens were actually deprived of voters' rights up until 1994. So that's why from a purposive point of view, it becomes incumbent for members of organization to be afforded to vote for the organization of their choice. So they cannot be disenfranchised because of the system that, well, I know that I didn't click okay, but from a purposive understanding point of view, proper interpretation, the submission that I want to make is, when considering the history of the Republic of South Africa, majority of all people were disenfranchised. Number two, it's for them to be afforded an opportunity to choose those who they want to elect within the meaning and definition of Section 19. But other than them considering generous interpretation, it's quite broad, justices, in the sense that it says that you need to allow individual citizens, those that are voting or those that want to participate in the election, to be voted in, to enjoy that fullest right. So that's where we are currently. We are saying, IEC says, it's your own misfortune. I closed the it was only for misfortune. All right. Let's say, for instance, in that case alone, that my unfortunate that I was unable to claim. But they avoid Section 28. That tells them that no, regardless of the fact, whether you have timelines, whether you cannot condone 28 priority, it says that inform us, inform the applicants why couldn't it then apply, and it gives them stages that they need to do in order for them to participate. So those are the points that I don't want to do further, that I wanted to make submission in relation. So I'm partially then open for the questions. So the points that I want to make for the closure is, one, I've referred you to the Section 28 to say that consider it for the purpose of the thing, of the question that the opening of floodgates of heaven, floodgates of other organizations in such a way. The second point, I said 27. Consider 27 within the text, context, and the purpose and the proper interpretation. I've seen the IECs avoiding. What IEC done, they've adopted the so-called, the so-called literal interpretation. They just said, you know what, 27, non-compliance to 27, you're out. So consider Section 27 when you look at within the text, context, and the purpose, we complied. And the third point that I also want to make is, even if the court was unable to agree with me, it's incumbent, I make a submission that the third point, that consider Section 39, Section 39, subsection 2 of the Constitution, when because the right at stake, it's one of the most important rights And also the fourth point that I also want to make is it does not necessarily raise material disputes of facts, in the sense that IEC also has considered to say, all right, we are all on misfortune that we are unable to click, and as a result of that, all the processes that we did were followed. I don't want to canvass a lot because our learned colleagues have actually canvassed the most important points. So I'm open for the questions, just as a relation to this.
Thank you, Mr. Emeliti. Can you just, for my own edification, explain this to me? Do I understand your case correctly to be that the fact that your client was locked in by deadline 5 p.m. is enough? That complied with the requirement, even though it locked in literally a second before 5 o'clock?
That's my submission, but can I answer like this, Chief Justice? When we consider 27, the method that IEC deliberately chose, it said that you must submit electronically. So when you consider 27, all of those things we submit. So to answer, yes, we comply, because of the timelines, that 5 o'clock we make it, so we comply within section 27.
And how does section 28 assist your client?
28 may perhaps, so 28 its causes as follows. The heading is non-compliance concerning submissions of the list of candidates. Subsection 1, I'll only read subsection 1. Subsection 2, subsection 2 specifically, it says, if registered parties has submitted a list of candidates and has not fully complied with the section 27, subsection 2A and 24, electoral officer, the most important, must notify the parties for non-compliance. So it's in parameters. So it assists me that if I'm not complying, it becomes incumbent upon IEC to have informed us immediately that it did not comply. That's number one. Number two, it says the notification must be given in a prescribed manner, but not later than relevant dates stated in the election timetable. So how it assists us is, all right, I may not have complied, but IEC tell us that we do not comply and give us an opportunity for us to rectify. It's on that basis that section 28, it assists us in these instances.
And which date would the date mentioned in subsection 2?
Subsection 2, it says the notification must be given in a prescribed manner by not later than relevant date stated in the election timetable. And must
which date would that have been?
I would presume, I presume it would not necessarily, in a strict sense, it cannot be the 8th, which is the time deadline. I presume it may be even the subsequent date after the date of the question of the submissions. But how then would IEC be able to notify that we didn't comply? It would only have been after the 8th. It would only after the 8th that we didn't comply. Then after the 8th, then we didn't comply. Therefore, for it not to be disturbed with other dates, it can be any day after the 8th, Chief Justice. That's the point that I just want to make.
And your client no longer relies on load shedding? Load shedding
well, it's holistic. On the aspect of load shedding, it's not that the point that we want to make, of course, and that day there was a schedule of load shedding in the sense that it affected us for further submissions. But regardless of the fact that even if when it came back, we were still able to proceed with the things of manual, of all electronic submissions of candidates. It's part of it, but the primary aspect of it is that one of us kicking out at the timeline, of kicking us out of the system.
And the non-compliance issue, and if it's like that, how does then Section 28 come in? Because has it been technically submitted or fully submitted? If it's not in, basically, it doesn't look like the list was submitted.
So how does Section 28 comes in? Let's say in a worst case scenario, I did not substantially comply. It's incumbent upon me to comply in terms of 27. As an applicant, I need to comply. That's so far as I have to do in terms of 27. Then it comes incumbent upon IEC at 28. IEC then must inform us within the meaning of 28 1. It says that applicant did not comply. So that's where the IEC then comes from to say comply. Then it says, the language says, registered parties has submitted a candidate who's not fully complied in terms of 27. The chief electoral officer must notify that party. So it comes incumbent upon the IEC then to notify us that we did not comply. So it's on that basis I'm saying 28, it then assists us for the purpose of non-compliance of 27.
I'm looking at the timetable, para 10 thereof, or item 10, that says cut-off date for notice of non-compliance by content states in respect of lists. It says the chief electoral officer must notify a registered party that has submitted a list of candidates in terms of Section 27, but has not fully complied with Section 27 2A, B, C, A, and G, or 27.4 of that non-compliance by 18 March 2024. So the first question is the submission part, the list must have been submitted.
Yes.
Now yours was halfway. The halfway part, can one then say it's submission or what? It has to be submitted before the CEO can then notify the party of non-compliance.
So the sensible interpretation would be in terms of 27, sensible interpretation is our supporter to submitted. The system allowed us to pay, we paid. We then submitted candidates. Even though some were successful, others were not. So sensible interpretation would then be as we qualify in terms of 27. Whether it's strict or substantial, it's a different scenario altogether, because IEC then even the portal then demonstrated that indeed the other complied substantially complied. So what the OP have done in terms of 28, in terms of the calendar, OP have told us it's nothing that they've done to us. They've never told us anything. So to answer, yes, it's supposed to have told us I think 28 that we did not necessarily comply. That would be the sensible interpretation, Justice. I would say the OP have been done. But as we spoke, IEC never notified us that we didn't comply. Whether it's strict or substantial.
Do I understand the relief that you seek? Do I understand it correctly that you seek an order that you and you alone be permitted an extra window period to do what has been done?
That will be the prayer that we just to submit. Yeah, that's the prayer that would, if the court was to agree with us, that's the only application that we request, that we give an opportunity to submit the remaining.
This court has said in a number of judgments that the Commission must be even-handed. The Commission must be seen to treat parties equally. So you can't make special indulgences for some and not for others.
Just so hence I indicated in our, I said, all right, if, for instance, I'm defeated, we are defeated on Commission give us an opportunity to supply. But as a matter of law, 28 informs them for them to afford an opportunity to tell us why we didn't comply, then we were able to comply. So as a matter of law, we need to be notified. As a matter of law, we need to be notified, and then we deal with the defects of non-compliance. So on that basis, I hear what the court is saying, that we need to be. So if you are to strike a balance, let me look at the analogy on the proportionality. It's at 27, 28 gives an opportunity for us to rectify the defects that we have in 27. So it wouldn't necessarily be opening the front of it that allowing other parties to be given an opportunity. So it's on that basis I'm saying, on the matter of law, we can be assisted by 28. Let
me read you what this court decided in Liberal Party about Section 28. The Liberal Party judgment at paragraph 22 says the following. Section 28(1) provides for condemnation and rectification, and here comes the important part. Quote, if a registered party that has submitted a list of candidates has not fully complied with Section 27, fully complied, close quote. Now, you can't even claim substantial compliance. But let me read further. That's just in brackets. Quote continues. As such, contrary to the applicants, that's the Liberal Party submission, Section 28 does not vest the Commission with the discretion to condone late submission of candidates' lists, but only to allow the rectification of other failures to comply with Section 27. The applicant had not submitted the list by the deadline and is therefore not entitled to rectify its non-performance in terms of Section 28. How is your case different than that of the Liberal Party in this case?
It's quite clear. As we were on time, we're within 28 and the 8th. We are not out of time, we're within time for the 8th. It was only that.
No, I don't understand. Let me just clarify this. One of the parties says by the time the deadline came at 5 o'clock, I think it was the Labour Party, all the stuff were in boxes. You say your stuff was in the computer. That's not what submit means. What does submit mean? It's like saying the check is in the mail when we still used to write checks. You haven't paid until the check is on the other side and it's been deposited, don't you?
Just would you allow me to talk a computer language? I think probably it's important for one to clarify from a computer language point of view.
I hope I can understand.
With the greatest respect, so deadline. Let's talk from a manual point of view. From a manual point of view, it will make logical and sensible sense to say that we're supposed to have been there at 5 o'clock manual. It could not. It's a different situation, I understand. Now let's come to this scenario. IEC chose electronic submissions. So at just before 5 o'clock cutoff, the names were already uploaded in the system. They already uploaded in the system, so they will be sitting somewhere in the cloud of the IEC. So to answer that question, yes, we're within time. It's only that we're only supposed to just do a last stage, then the system kicked us out. So it's not a scenario where we are saying that the system, 5 o'clock came, then you wanted to submit after 5 o'clock. It's not the case that we're trying to make. So to answer the question is that our names were sitting there in the portal for the purpose of them to do. That's why they were able to, in the printout, that's why in our own printout, they're able to see that indeed others were qualified, others were just out of time.
Can you take me to your papers, your founding papers in the Electoral Court, and show me where you refer to this clicking, where you were supposed to click finish and it kicked you out? Where is it in the affidavit, please? If you can't find it now, we can always get back to it later as my other colleagues proceed. Maybe your juniors can check in the meantime. But if you can't put your finger on immediately, you can park it for later. Just remind me to come back to it though, because I forget. Can I ask you something else? Did you bring this review in the Electoral Court in terms of parliament?
We sought a declarative order.
Well, let me backtrack. Sorry, I was one step ahead. Did you bring a review application?
In substance, it was a review application.
So, what is the decision that the Commission took? Where do we find that decision?
So, just a minute. Let's talk about the jurisprudence of administrative action. I think it's important.
No, just show me in the papers or in the act, in the Electoral Act. Sorry, in the papers. Where's the decision?
I just wanted to demonstrate that issue. The submission was done electronically. It's not manual. So for the fact that the system kicked us out, one probably from a persuasion point of view, you would say that purely from a persuasion point of view, for the clicking, for the system to kick us out, purely from a persuasion point of view, I would say that one would, even if I may not necessarily have an authority in law, but from a persuasion point of view, I would say that the kicking out would then follow through the parameters and the definition of administrative action. I don't have an authority. I'm merely persuading to that, so that would then, those will be the decision, electronic decision that have got direct and external legal effects
Hang on, maybe I'm just being obtuse, but explain to me. See, the reason I'm asking this is PAJA, as you know, in Section 1 defines what a decision means. So what is the decision here, and where do we find it by the Commission?
Just much, I'm too liable. I don't want to create dialogue with great respect. So, the choice, IEC ordinarily decided that submission must be done electronically. That's number one. So, PAJA is quite clear. Let's say definition, the definition of PAJA decision has been only confined.
Okay, now I understand. Sorry, I missed
to the decision. So it was.
Sorry, now we're on the same level. Let me ask you this then. Two things. Firstly, it wasn't just electronic submission. You could also deliver physically, except for the signatures which had to be scanned and so on. You could do it physically. You accept that?
But the only office that was only allowed was in the Free State. So the only office that was allowed was only National Office in Centurion. Yes, you could have regularly, but logistics strictly at that time it dealt with us because of the distance from Bloemfontein to Centurion.
Now that decision for it to be made either online or physically only at the head office in Centurion, that decision was made in terms of regulations. Do you accept that?
I do accept that.
Have you challenged the regulations?
We didn't really challenge regulations because the issue was not necessarily about either the rationality and reasonableness of the thing, of the regulations. It was merely to say that, just declare that for us an opportunity to finalize our submissions.
You see, Mr. Awai, how they work is like this. They look at the act and they look at the regulations and they work out how they're going to do these elections, the run-up to it. And so they pass regulations as subordinate legislation to say, we would like to have these things done electronically or physical delivery there. That's the fount of the foundation, the origin of their decision then to pass an item 9, a deadline for submissions. So surely you got to challenge that. The origin, the regulations, the act, and it's unchallenged. Or even the election timetable. But that is not your case. It wasn't your case in the Electoral Court, right?
Can I say something? In the language of agent court in the lower courts, it was in such a way that extreme, at that time when we prepared the papers, so at the time when the papers were prepared, the issue was only another issue of allowing us to make our submissions on the portal. So that's one of the most challenging of the thing of the regulations was not one of those that we considered.
So are you saying now that your case isn't that the portal didn't work? It was the choice they made for how you should submit?
Our case, it's as a result of one, I indicated one. So from a sequence point of view, what will then happen is, let me do the first stage. The first stage that you submit, then it will then generate a report. So because of the delay of generations of the report, and also our submission, the bulk submissions, it didn't assist us to be able to click on time. So that's a submission that I just want to make so far at this point. I don't know if I was able to answer your question.
See, Mr. Ramaili, I think what happened here was you misunderstood how the process works. You thought that you first had to upload all your signatures and do the payment deposit before you could do the candidate submissions. I think you said somewhere in your papers in the Electoral Court, you said that the OCMS is designed in such a way that in order for the unrepresented party to create payment reference and make nominations, that's the candidate list, it must first comply with Section 27(2) small c capital B 1 and 2 of the Electoral Act. That is the uploading of supporters. And that's wrong, isn't it?
I mean, not necessarily our understanding of the system is was designed. We understood that you move from one stage, then once you're done with another stage, then it allows you to open a second stage. That's how we then understood the system to be okay.
Well, all I'm saying to you, it seems to me it was a misconception. All you had to do, as I understand it, you decide which of these basically 10 elections, one National Assembly and 9 provincial legislatures I want to participate in. You then ticked it on the computer, and there's generated a payment reference. Once you have that, you can do all these things simultaneously. You could do supporters upload signatures, you could do candidates uploads, and you could start doing this as early as 23 February, if I understand it correctly. Not so.
We could, but we also have done that. From a sequence point of view, we started as early as February, all the sequences moving up until the last day, the 8th. That's what we actually did in our case. And IEC also conceded to that effect that we started as early as February, doing all the processes. But I hear what the court is saying in the sense that we would have made a payment, we would have done them at a go. But the challenge would have been the first stage where it requires verification of the IDs. That's the one that we not necessarily allowed to the bank. Then from Excel, even for product, that's the one. But the initial one, that's a pragmatic one that allows you to punch the IDs manually, then you wait.
You see, it seems to me you're still laboring under misapprehension. There's no first stage, second stage. The only first stage really is to generate a payment reference. And then you could do all these things all at once. You could even do it offline, prepare Excel spreadsheets, and then upload it on the system just once and for all. But it seems to me you're still talking about you first had to upload all the supporter and signatures lists before you could do the candidate lists. That is not how it worked.
I can't take it any further than the submission that I've made.
Thank you, CJ. Thank you.
Thank you, Mr. Roberti. You have no more questions.
That's concludes my submission.
Mr. Bishop.
Thank you, Deputy Chief Justice. Sorry, DCJ, I understood that I was getting 1 hour uninterrupted. Perhaps I misunderstood.
Okay, we have said 25 minutes, an hour. You want an hour?
I would like an hour.
We'll give
Deputy
you an
Chief
hour.
Justice. I'll try and be less.
Okay.
Thank you. One hour 45 is fine.
No! Okay.
Thank you, Deputy Chief Justice. The question in this case is, did the Commission provide a submission system that a reasonable political party could use to nominate candidates by the deadline? And that's a question of fact. On one side, you have objective evidence from the Commission that the majority of parties, and I'll come to the vast majority of parties, were able to successfully use the OCNS to submit candidate lists, supporter signatures, supporter information. We have objective evidence from the Commission's IT experts that confirm the system was working. We have evidence about what happened in the last half hour before the deadline closed, showing that thousands of supporters were uploaded and hundreds of candidates were uploaded. On the other side, what we have is subjective complaints. To say for us, it didn't work. We experienced difficulties. But the reality, if one looks at the facts, of each of these cases, the true explanation is that the system worked, but the parties didn't. They had enough time to use the system. They had more than adequate training to know how to use the system. But they underestimated the task, particularly the task of submitting the supporter signatures and information. They made mistakes. They didn't understand how the system worked, despite the training given by the Commission. They failed to take advantage of the system that allowed them to have multiple users simultaneously, that allowed it bulk uploads instead of manual uploads. And ultimately, they left compliance too late. And that's why the Electoral Court held that on the probabilities, the OCNS was not as ineffective and cumbersome to use as the applicants would make it out to be. It follows that it was, as alleged by the Commission, the applicants' unpreparedness and their tardiness which resulted in their inability to comply with the provisions of Section 27. The Electoral Court reached a similar conclusion in two similar matters in a case decided on Monday, Arise South Africa. Of course, it is unfortunate that these applicants, that these parties will not compete in the elections. It is unfortunate that their supporters will not be able to vote for the parties they want to vote for. But the reality is, in order to have an election at all, there have to be rules. And the Commission has to enforce those rules. And the reality is that those rules will mean that some people do not comply. But that does not result in a limitation of rights. There's only a limitation of rights if the Commission failed to afford reasonable parties an opportunity to comply. So, with that introduction, I intend to address the following topics. I want to start by just clearing the weeds and getting a few issues out of the way. I'm then going to deal with what is the case for this court, what is the legal standard, and what is the factual standard, and the application of classical evidence. I'm then going to set out the Commission's positive version of the evidence that shows the system worked positively. This is not a case where the Commission just put up a bare denial and just denied the allegation that the system didn't work. It puts up positive evidence to show functionality. I'll then deal with the applicants' versions and why they do not create, either on the probabilities or applying classical evidence, show that the Commission version is far-fetched, clearly untenable. I'm going to do that thematically, looking at all three parties. I'm then going to deal with each of the applications in turn and go through the Labour Party, ACT and AASD and deal with their specific facts and the specific issues that arise in each case. I'm then going to deal with jurisdiction and finally with remedy. So to begin with just clearing some weeds, I think it's important to be clear about what the case is not about. So this case is not about the legality or the fairness or the reasonableness of the supporter and signature requirement. This court held in One Movement South Africa that it was an onerous requirement for independent candidates, but it decided to leave it in place for unrepresented parties for this election. That is the law. It may be that in the future this court decides that the requirement is unconstitutional, but for the purposes of this case and this election, it is a constitutional law. It's also not about the requirement that candidates' details must be submitted online or only at the head office of the Commission. In many of, we didn't hear it today in oral argument, but in many of the affidavits and heads of argument that are being filed, there's a complaint about this, that it's unfair to require parties to submit it online. But that issue would only be before this court if there was a challenge to the regulations. The fact that you can only physically submit in Centurion, that, whether that is lawful or not lawful, would only be before this court if there was a challenge to the regulations, and there is no challenge. This case is also not about the digital divide that the minority of the Electoral Court mentioned in its judgment. The issue was never pleaded in the Electoral Court by any of these parties. Indeed, these parties all say they are very tech-savvy. They're on the right side of any digital divide. And in any event, it would again require an attack on the regs that established the OCMS. This case is also not about the importance of the rights in Section 19. Mr. Am gave a very passionate reliance on those rights. And he's right. These are vital, central rights for our democracy. But as I'm going to submit, those rights are defended by what the Commission did in this case, by establishing a reasonable system and holding parties to that system. It's also not about the tone that the Commission adopted. Mr. Am took issue with the tone and the approach of the Commission, and I think those attacks are unfair. He complained that the Commission said that these parties had failed to comply. Instead, it was objectively impossible for them to comply. But that's a whole debate in this case. That's the debate between the parties. The Commission says they failed. They said it was impossible. It's not inappropriate for the Commission to use that type of language. Nor is it fair to say that the Commission has withheld any type of information. We have given the information that has been requested. The Commission had to respond to, at current count, I think 12 similar applications. Each one of them had to be responded to within a couple of days in the Electoral Court urgently. And the Commission has done the best it can to put up as much relevant information as it can in each application. So really the case is only about one thing: whether the Commission provided a system which a reasonable party could have complied with. In my submissions, I don't intend to distinguish between whether this court should refuse direct access, refuse leave to appeal, or dismiss the applications on the merit. The Commission's position is that it should refuse direct access, and it should dismiss the applications for leave to appeal, because there are no prospects of success, and it's not in the interests of justice. But I'm going to address the court on the basis that the cases are before it on the merits, and just address the court on the merits. So that gets to what is the legal standard for this court? What is the test? And the case, it's being presented differently by different parties and at different stages. But I think really what the case is that the Commission limited these parties' Section 18 and Section 19 rights because its conduct, the way that it supplied the OCNS, the way that it managed the OCNS, made it objectively impossible for them to comply with the requirements of Section 27 by the deadline. And we agree that's the correct form of analysis. And we know from One Movement South Africa that in this type of situation there's two types of cases. There's a type of case like One Movement where Parliament enacted a law that actively restricted the ability to stand for political office. And that was the intention of the signature requirement for independent candidates, to make it more difficult. And there the law, the conduct, just because it makes it more difficult, limits the right. But there's a different type of case, the case that was at issue in the New National Party, which is where the government, through law or conduct, gives effect to the right to vote or the right to stand for office. So New National Party, the requirement to have a barcoded identity document was a step that this court held was necessary for the realization of the right. Because in order to have free and fair elections, you need to ensure that only people who are on the voters' roll vote. And this is that type of case. Because there's no dispute in this court that the OCNS is designed to facilitate participation and management of the election. So it was adopted initially to help political parties to get around the difficulties of physical submission by ensuring that parties could submit 24/7 from anywhere in the world. And it also assists the Commission in its management of the elections because it allows the Commission to check in real time as parties put up ID numbers of candidates or supporters that they are on the voters' roll, the correct segment of the voters' roll, that they're still alive. And it alleviates the massive administrative burden that the Commission faces and is significantly higher with the new Section 27(2)(c) capital B, the supporter requirement, of taking all that physical paper and then collating it and checking, going through it and checking each supporter, 47,000 supporters each party needs to compete in all the elections. So if it received all that in paper, it would have to go through every single one of them and check that that person is a valid vote on the right section of the voters' roll. And so all of this is designed to facilitate a free and fair elections. And so then we get to the test, and it's said clearly in One Movement South Africa, paragraph 258A, where the court says, where impugned law or conduct gives effect to the exercise of a right to vote, it only limits the right if it is shown that its probable consequence is that those who want to exercise the right will be unable to do so, even though they act reasonably in pursuit of that right. So we have to show the probable consequence, so those who want to exercise it will be unable to do so, even if they act reasonably. That's the standard in this case. And the court in New National Party recognized, this is at paragraph 20 of New National Party, that any scheme designed to facilitate the exercise of the right to vote carries with it the possibility that some people will not comply with its provisions. But that does not make the scheme unconstitutional.
Sorry, Mr. Bishop, what paragraph is that? National
20. So that's the legal standard here. Then we get to how should this court resolve the dispute of fact? What is the role of classical evidence? And the case, I'll get to this in some detail when I deal with each party, but the case has narrowed quite considerably from what it was in the High Court with the Labour Party on the 8th of March, when we argued the case in the Labour Party, in the High Court, through the Electoral Court to this court. As I understand the focus of both the Labour Party and ACT, their primary complaint is that on the 7th and or 8th of March, the OCNS was not operating correctly. That prior to that, it was working smoothly, but on those days it wasn't working properly, and therefore it was impossible for them to comply. That is a question of fact. Either it was working or it wasn't. And it should be resolved according to Plascon evidence. The Commission's put up a version, which I'll get to, about showing that the OCNS worked. And the applicants can only succeed if they can show that the Commission's version is so far-fetched or clearly untenable that it should be rejected out of hand. I'd like to address Justice Bilchitz's question about the possible development of Plascon evidence. And we said it's not appropriate to develop it at all, and definitely not in this case. This court endorsed Plascon evidence for the constitutional disputes in the rail commuters case. The Electoral Court has repeatedly endorsed it and applied it in election disputes. I don't have all the cases with me, but in front of the Electoral Court, we put up a list of, I think, 5 or 6 cases in the Electoral Court where it applies Plascon evidence. And this court has applied it in a directly analogous matter, which is a Democratic Alliance, In Re Electoral Commission of South Africa versus Minister of Cooperative Governance. The citation is 2021 ZACC 30. And that was a case that followed on the COVID postponement case. So after this court refused the Electoral Commission's request to postpone the 2021 local government elections beyond the constitutional date, the Democratic Alliance, and I was then acting for the Democratic Alliance, approached this court to complain that the Electoral Commission had reopened candidate nominations. And it said that this court's order only permitted the reopening of voter registration, not candidate nominations. And it said it accused the Electoral Commission of bias. So what this court said at paragraph 40, it said, in short, the DA alleges that the Commission's decision is biased and improper, and is inconsistent with the even-handedness demanded of an independent electoral body. The EFF alleges that the ANC will be disproportionately benefited by the extension of the cutoff date. It is not possible, however, on these papers, and in conformity with the Plascon Evans rule, to reject the Commission's denial of these imputations. So this court's applied Plascon Evans in an electoral case about candidate nominations. The case that Justice Bilchitz referred to, Machala versus Kombombini, is again, it's really an application of Plascon Evans, because what happened in that case is that the applicant's version was corroborated by confirmatory affidavits that there was a customary marriage. The respondent just put up a bare denial. And in those circumstances, Erasmus J. held that he would adopt the version of the applicant. But that's not a departure from Plascon Evans. The cases from Whiteman and so on, they say if you just put up a bare denial, that doesn't create a dispute of fact, particularly if the version of the applicant is corroborated. So there's no need to change Plascon Evans for electoral disputes, and it certainly shouldn't be done in this case, where the issue has not been argued by the parties. And in any event, I'll submit that it will make no difference, because the alternative to Plascon Evans is deciding it on the probabilities, looking at the affidavits and deciding what's more probable. If you do that on these facts, you will still reach the same conclusion as the Electoral Court. So against that background, what the test is, did the Commission create a system that a reasonable party could use to comply? And bearing in mind the Plascon Evans test, I'm going to turn to the Commission's positive evidence. And there's 6 forms of evidence that I want to go through. The first is the time that the OCNS was open. The second is the training that the Commission provided. The third is the functionality of the OCNS. The fourth is the success of other parties using the OCNS. The fifth is the lockdown IT report. And the sixth is the activity in the last half hour. So on the timing, this is set out in the heads of argument, so I don't want to belabor it. But the important point is that parties knew from April 2023, unrepresented parties, that they would be required to submit large numbers of supporters' information and signatures, because that's when the amendment was made to the Electoral Act. The Commission opened the OCNS to allow parties to begin uploading that information on the 26th of January 2024, so that's 42 days before the deadline. It opened the OCNS for candidate nominations on the 23rd of February, which is 14 days before the deadline. And the reason it had to wait is because it had to wait for the proclamation of the election by the President. So, and parties also knew from 2019 that there was an election coming sometime between May and August this year. So they knew roughly when the election was going to be. And ultimately, the deadline of the 8th of March was dictated by the election date. Because the Commission explains in its affidavits that through its experience, it's realized it needs at least 86 days from the date of proclamation to the date of the election. And it knows how much time it needs to do to perform each step. So the 8th of March date is set based on the time it needs after it receives the candidates to go through the process in section 28, 29, 30, and 31, deal with all the objections, notify parties to deliver further documents, so that it can ultimately finalize who's on the ballot and who's not, and it can print those ballots. So the first question is, did the Commission give parties enough time? And the answer is yes. The second question is, did the Commission do enough to assist parties, to explain to them how to use the OCNS? There's some allegations in the papers that this is the first time the OCNS is being used. That's not the case. It was used in the 2019 national election. It was used in the 2021 local government election. It's been used in by-elections since then. What's new is the signature requirement, because this is the first election in which that signature requirement has existed. But the OCNS has been used since 2019. And the Commission took multiple steps to inform particularly unrepresented parties, because represented parties should know how to use it, they've used it before, but particularly unrepresented parties, how to use it. So they held a training on the 29th of January for all unrepresented parties. ACT and AASD were present at the training. The Labour Party wasn't, because it had not yet completed the process of registering as a political party. It held 4 workshops in February and early March, different places across the country. Both the Labour Party and ACT attended those workshops. It produced multiple guides, help guides, explanations, which are all in the papers, which I invite the court to look at. I don't intend to take you through them. But they show step by step, with screenshots of the system, how to use it in extensive detail. The Commission's officials were also available on email, WhatsApp, and by the phone. And applicants made use of this. There's 2 good examples in the Labour Party case. When Mr. Jans van Rensburg was trying to register as an OPA, he initially sends the notice, then you get a verification link, and you have to confirm it, so you can confirm your email is correct. And you have to do that within 24 hours. He waits too long. He then writes back on a Saturday to the Commission's officials and says, "Oh, it hasn't worked, please help." And the Commission's officials are helping him over a weekend. On Sunday, the 3rd of March, at 16:45, he sends an email to the Commission saying, "I'm not able to use this particular function. This isn't working for me." The Commission replies at 18:43 on a Sunday, 6:45 on a Sunday, 2 hours after receiving the message, explaining what the problem is. He was using the wrong tab. And he responds at 18:49, "Now it is working, thank you." That's PSM 18 to the answering affidavit in the Labour Party case. So did the Commission do enough to train, inform, and assist parties? Yes. The next question is, was the OCNS itself as a system functional? And I'm not going to go through everything, but I want to highlight certain elements that have come up in the debate. The first is that the OCNS allows multiple users. The Patriotic Alliance, Justice Majid mentioned, had 189 users. And the idea was that you could have different users working on different provinces, for different elections, or some could be doing candidates, some could be doing supporters. You could have as many as you like. And once you had an OPA, an online portal administrator, he appoints the users. You can just do it yourself. You don't need the Commission's intervention. You just appoint the additional sub-users. And then they can all be working in parallel. So the number of users you have is a bottleneck for how efficiently you can use the system. And it's something over which the Commission has no control. It cannot dictate to parties how many users they use. And in this case, Labour Party only had an OPA, had no sub-users. ACT had its OPA at 1 sub-user, and the AASD had the OPA at 4 sub-users. So you're already, by doing that, limiting how fast you can upload information into the system, despite the fact that the Commission made it available to you to use as many sub-users as you like. The second point is that you can do all the different functions, the 4 functions, uploading candidate information, names and the supporting documents, uploading supporters' ID numbers, uploading supporters' signatures, and paying a deposit. You can do all of those simultaneously. As soon as you tick the checkbox of which election you want to compete in, you can then generate the payment reference and you can immediately start doing all those functions for that election. I'm going to get to some of the papers on that later, but one of the big mistakes that ACT and AASD made is not to realize that. And they wrongly thought that they had to complete certain functions before they could upload candidates. The third is that it permitted bulk uploading. And so it's important to be clear about what this is, because I think Mr. Ramaile confused it slightly. You didn't have to upload your candidates' names and ID numbers first manually and then in an Excel spreadsheet. It was either or. You could choose to do it one by one and fill in each candidate's name and ID number, push enter, fill in the next one. Or you could offline prepare a spreadsheet that had all your candidates or all your supporters in the spreadsheet, an Excel document, and then you simply upload that document with all your candidates for that election. So let's say you want 400 candidates to stand for the National Assembly. You put them in one Excel spreadsheet, upload it, all your candidates have been uploaded. The same for supporters. With supporters, the only difference is you could only have 1,000 supporters per spreadsheet. So for some of the elections, you would have to upload several spreadsheets. But that was the only limitation. And the important thing about bulk uploading is that the actual putting in of the information happens offline. And so whether the OCNS was working or not would make no difference to your ability to fill in that spreadsheet. The fourth element of the OCNS is that it provided feedback. So it would tell parties how well they were doing, how many signatures that had they uploaded, and track progress. The fifth and final point to make is that it was not the only option. Parties could submit all their candidate information physically in Centurion, and particularly for the Labour Party and ACT, where that was half an hour to 45 minutes drive away from where they were. That was a real option. You could also provide your supporters' signatures physically. So it's important to distinguish between the supporter ID numbers and names. That had to be done online so that the Commission could check it in real time. But the signatures could be provided physically to the Commission. Now, Mr. Loxton is right that that's not permitted in the regulations. But an email was sent to all the parties on the 6th of March. It's PSM 21 to the Labour Party papers. And perhaps I can just read it. It starts with a list of all the parties that were sent to you. And then it says, at paragraph 6, an unrepresented party or independent candidate must have captured the requisite signatures to contest the National Assembly or Provincial Legislature. You have to capture the ID numbers yourself on the OCNS. The ID numbers have to be on the OCNS. Submit the same lists that you've captured on the OCNS. So parties had lists where people would fill in their name and then they'd sign. So capture the same lists that have been captured on the submit the same lists that have been captured on the OCNS, either by uploading the documents onto the OCNS system or delivering the same by hand by no later than 5 o'clock on Friday to the Centurion office. So it's very clear that it's providing that additional opportunity for parties. So the question is, was the system, the design of the system, was it adequate? Could a reasonable party making use of the system have complied with the deadline? Yes, absolutely. It was not complicated or difficult to use. If used improperly, it was incredibly effective. So that's the one end of the evidence, what the Commission did positively. And then you can look at the results. What is the results of the system that the Commission designed? And there's three parts to that. The first is the success of other parties. So we know that there are 70 parties who will be on the ballots, who use the OCNS and will compete. That includes 56 unrepresented parties. 33 of them are competing in all three elections, in the sense that there are at least one provincial ballot, one regional ballot, and the national compensatory ballot. 18 are only on one or more provincial ballots, and 5 of them are only on the national ballot. And the Commission gives examples of unrepresented parties who are able to use the system. Rise and Zansi, Action SA, the PA, who are all competing in all these elections. They all managed to comply. They all used the system. We give the example of the ELFSA, the Economic Liberated Forum of South Africa, which only got registered on the OPA, only registered an OPA on the 7th of March, the day before the deadline. It is competing in all three elections, national, compensatory, regional, and provincial, despite only starting on the 7th. The AIC was in a similar position. The AIC is a represented party, not an unrepresented party. But it also only started on the 7th and is competing in all these elections. And these parties use the same system, but they were able to comply. So the idea that reasonable political parties could not comply is simply inconsistent with these facts. That brings me to Mr. Loxton's big point that he started with. And it's really said that there is no more important fact than this one. But it's a damp squib. The claim is that 35% of unrepresented parties were unable to compete because of the OCNS. That's the claim. That the OCNS is the reason that they were unable to compete. But that is not the evidence. And the evidence appears in paragraph 108.2 at page 35 of the Commission's answering affidavit in this court. Unfortunately, the papers are not paginated, but it's page 35 of the answering affidavit. So what the Commission says is 18 unrepresented political parties that sought to participate in the national elections did not meet the requirements to do so. That's all the Commission says. And it's all the Commission can say, because the Commission cannot know why these 18 political parties were unable to meet the requirements. It cannot know if that's because they were unable to gather sufficient signatures. They registered an OPA, but never gathered the right number of signatures. Or they never got around to nominating the candidates because of internal political party strife. Or they only started 5 minutes before. We don't know. The Commission cannot know why they did not comply. Mr. Loxton tries to twist this evidence into evidence that they didn't comply because of the failure of the OCNS, because he says that's the question his attorneys asked. But you've got to look at the answer that was given. And so this number, that 18 out of the 50, it's actually 56, 18 out of the 56 unrepresented parties were not able to comply, just doesn't tell the court anything. Because unless we know why they were unable to comply, the numbers mean nothing. What we do know is that of the 10 parties that have taken the Commission to court so far, the Electoral Court has found in the Commission's favor in each one of them. It's found that the reasons for non-compliance were not the failure of the system, but the negligence or tardiness of the political parties. That's what we do know. So with respect, the number really doesn't get anywhere. So the first important part of evidence is that reasonable political parties could comply. We know because they did. The second part of the evidence is the evidence of lockdown IT. And the evidence is that it was 100% uptime. And I want to read from paragraph 17 of the affidavit of Mr. Sukunan, which is attached to the Commission's answering affidavit in both the Labour Party and the ACT matters. And this is what he says. The website demonstrated exceptional stability, ensuring uninterrupted access for users. Such a high level of uptime is indicative of a well-maintained and resilient website infrastructure, capable of handling potential challenges and maintaining consistent online performance. That's the evidence of the Commission's service providers. And the evidence belies the claim that the system was constantly slow or glitched. I should deal briefly with the status of that evidence. It is evidence in the Labour Party matter. It's a direct access application. It's put up in the answering affidavit in the direct access application. So it is evidence. in the ACT matter, a different version of the report was put up in the Electoral Court without a confirmatory affidavit. When answering in this matter, because the Commission was putting it up in the Labour Party matter, we put it up in the ACT matter as well and asked for permission to introduce that further evidence on appeal. We submitted it in the interest of justice for this court to admit that evidence. One, because it's directly relevant. It's not entirely new evidence. It's very similar evidence to what was put up in the Electoral Court. And it is in any event before this court in the Labour Party matter. So the last positive issue showing the results of the system the Commission designed is what happened in the last half hour. And this appears in PSM 23 to the answering affidavit in the Labour Party matter. So it shows what was uploaded to the website from 16:30 on the 8th of March. And there were hundreds of candidates, thousands of supporters, and dozens of bulk uploads, all in that last half an hour. So this is it's just not a system that stopped working. It's a system that was working for all these parties. So that's the Commission's version. Is it so far-fetched or clearly untenable that it can be rejected? No. The evidence is mutually reinforcing and corroborating. The Commission provided a user-friendly system, adequate training, and enough time to use it. And the majority of parties used it effectively. There's no party that the Commission knows of, other than those who've elected before this court, who can show that they were unable to comply because of the system. We don't know why those other 18 parties who haven't come to this court or the Electoral Court could not comply. And the stability of the system is confirmed by the service providers and by what happened in the last half an hour. So then we get to the applicant's version. Have they put up evidence to discount what the Commission has put up? And they really put up two types of evidence. So one is their subjective experience, and the second is arguments based on inference. So the subjective experience effectively goes, we are telling you that we experienced difficulties, and there are other parties that complained about the system, therefore the system didn't work. That's the logic of the argument. But the argument is wrong, because what the Commission had to do is create a system that enabled reasonable political parties to comply. And if we can see that the vast majority of political parties were able to comply, then the fact that some parties may have experienced glitches in the system is not evidence of unreasonableness by the Commission. It's not evidence that they failed to provide a system that a reasonable political party could use. Because in this type of case, whether there was a limitation of the rights is an objective question, not a subjective one. It's not enough for a single party to come and say, I struggled to upload. They've got to show that the system would have made it impossible for a reasonable party to comply. The second is that the complaints may or may not be valid. There are other explanations for why any individual political parties may have experienced glitches or freezings or being locked out. It could be their internet connection, it could be something wrong with their computer, it could have been the way they were using the OCNS. The Commission can't be there sitting behind every user of the OCNS to figure out why you experience this particular glitch. It operates the back end. It sees the reports from its service provider, it sees what all the political parties are doing, and what it sees when it looks at that whole picture is a system that works. It's also interesting to note that these versions are inconsistent. The Labour Party says that the system didn't work on the 7th and 8th of March. ACT says it was only on the 8th of March. And they all accept it worked fine up until then. But that's not the way that internet systems work. It either worked for everybody, or if it didn't, then all parties would have experienced difficulties over that period. If only a few parties experienced difficulties, the problem is not with the system, it's with them. So when I describe these as subjective problems, I'm saying they go to the individual parties' experiences, not to whether the system worked or not. And that's the case that the applicants have to make. The second type of argument they make is not a case really based on evidence. It's a case based on inference. So they say, well, the Commission says it could have been done in one day. We were unable to do it in one day. Therefore, the system didn't work. That's the logic of the argument. But the logic doesn't follow. What the Commission says is the uploading could be done in one day if you had collated all the information and collected it in the proper spreadsheets and all you were doing is uploading it. That you could do in one day. But if you weren't able to do it, and other parties were able to do it, the inference is not that the system didn't work. The inference is probably that you didn't use the system properly. And particularly when one looks at the case of the ELFSA, that was an unrepresented political party that was able to comply in 2 days, the Commission's estimate is accurate. And if other parties were unable to do it in the same period of time because they didn't use it properly. So that brings us to what are the real reasons for non-compliance. I'm going to skip through these because I want to get to the particular cases. But essentially there's three. There's the applicant's delays. So the parties waited extensively long. The Labour Party delayed its registration and only started uploading candidates 36 minutes before the deadline. AASD is the best one, or 1 second before the deadline, literally the second, 16:59:59. It first tried to upload a candidate. And ACT's only tried 2 hours before the deadline to try and upload its first candidate, even though it could have done so from the 23rd of February. The second reason for the non-compliance is really the difficulty of the signature requirement. It is onerous. It was difficult to collect those signatures. The Labour Party and the High Court explains its difficulties. But that's not a problem with the OCNS and the ability to upload information. That's a difficulty that will no doubt confront this court one day when the Rivonia Circle or some other party brings that case back to this court. But it's not relevant to whether the OCNS worked or not. And the third reason is that the parties made mistakes in the way that they used the system. They didn't register more users. They made the mistake of thinking they had to do things in sequence when they could have done it in parallel. They didn't make use of the bulk uploading, which would allow them to do a lot of the work offline. And they didn't submit physically when they could have, particularly the Labour Party and ACT. And so what's the conclusion? If one looks at the evidence of the Commission of how the system worked, and one looks at the paltry evidence put up by the applicants, and there's really no positive evidence to show that the system failed, other than to say, we experienced some difficulties with it. So when one looks at all of that, it is not far-fetched or clearly untenable that the OCNS worked. And even on the probabilities, it's more probable that the OCNS worked, and the reasons for non-compliance were the mistakes of the political parties. I'm now going to deal with each of the cases in turn, starting with the Labour Party. The first thing to deal with is the strikeout application. I don't want to spend too much time on it. There's two documents at stake. The Labour Party's reply and the supporting answering affidavits. The reply is pro non scripto because there's no application to admit it and it's not permitted under the rules. The supporting affidavits should be struck out because it's not permissible for respondents to put up answering affidavits that don't just say, that they go beyond just we support the relief of the Labour Party for exactly the same facts and that the Labour Party bases its application on. They put up new facts. Those facts are either just saying we also experience difficulties without explaining them, or they're facts which do go into more detail but which the Commission has had no opportunity to answer. So they should be struck out for that reason. The second issue, question of the Labour Party is issue estoppel. The court knows the doctrine, and it clearly is that it's the same issue that was before the Electoral Court that is now before this court. And an important point to make, which I think Mr. Am made, is that in front of the Electoral Court, the Commission was clear that if the relief was granted, it would need to postpone, or need to request the President to postpone the elections. So postponement was already on the table before the Electoral Court. It was put on the table by the Commission. Mr. Loxton wasn't in the Electoral Court, but I was, and that was my submission to the Electoral Court, that it would have to request postponement, and that's what the affidavits in the Electoral Court say. So this idea that while postponement wasn't a possible remedy in an appeal is wrong, because there was a remedy put up by the Commission already in the Electoral Court. So there's no reason why the Labour Party couldn't have brought an appeal, and this court should not countenance this type of abusive process, because it is prejudicial to the Commission, because each time you put up a new set of facts, and you lose on the one set of facts, and then you come and you hope that your new set of facts will do better. That's exactly what issue estoppel exists to prevent. So next on the Labour Party, it's important to note that the timing of what happened in the Labour Party case and how its case has changed. This case started in the High Court on the 6th of March. And its case in the High Court was not a case about difficulty in uploading documents. Its case in the High Court was a very different case. It said, this is at paragraph 19 of its answering affidavit in the High Court, which is annexure PSN 28 to the Commission's answering affidavit in this court. So, sorry, its founding affidavit in the High Court. And it said there are 3 obstacles. These are the obstacles it's experiencing. Why? And at that stage, it was asking the Commission to extend the deadline. It says there simply was not enough time to follow the prescribed process of securing the names, ID numbers, and signatures. It says more time is needed to canvass the electoral market. It says people were unwilling to sign because they were not registered. And it says the task of copying each person's name and ID number into Excel spreadsheets is simply unmanageable. And so on the 6th of March, it already knew it wasn't going to meet the deadline. And the reason it knew it wasn't going to meet the deadline had nothing to do with the OCNS. It had to do with its difficulty of getting enough supporter signatures and putting those in Excel spreadsheets, not with uploading them onto the OCNS. But now it comes to this court and says, no, the only difficulty was the OCNS was slow on the 7th and 8th of March. That's inconsistent with its prior version. And if we look at what are the actual reasons why the Labour Party struggled, and I submit there are 5. The first is that it waited until 36 minutes before the deadline to upload candidates, even though it could have done so from the moment the OPA was registered. Its first problem really is its delay in registering as a political party. And then its delay, the Commission informs on the 7th of February it's registered, and it waits until the 29th of February to try and register on the OCNS so it can start using it. That's unexplained. In the High Court, the Labour Party accused the Commission of not informing it that it had been registered. And the Commission then put up the evidence to say, no, we did send you the email on the 7th of February telling you've been registered, and you delayed for 22 days. The second is it didn't take the advantage of the opportunity to submit physically. There's no explanation. The third is it created its own bottleneck by having only one OPA. The fourth is that it didn't give itself enough time to gather and collate the information. It says, and this is at paragraph 31 of its founding affidavit in this court, that when the deadline was reached, we had all the paper documents in boxes, and when the portal closed, we still had several boxes of paper documents that had not been uploaded. But if we're talking about upload, you had to take those paper documents and convert them either into scanned documents or into Excel spreadsheets. That was a time-consuming thing, which on their own version they hadn't done yet. Otherwise it wouldn't be in paper, it would be on a hard drive. So those are the reasons why the Labour Party didn't comply. But then moving on to ACT, ACT did partially comply. ACT uploaded 50 candidates. It's on 8 of the ballots. It's on the national ballot, the Western Cape regional ballot, and 6 provincial ballots. But its version of what happened is revealing. It gained access to the OCNS on the 21st of February, but it only ever had its OPA and one sub-user. And it says that it uploaded all its supporters lists by the 6th of March, except for the Eastern Cape province. So it had done everything it needed to do by the 6th of March. But only then did it generate the payment reference so it could pay its deposit. It could have done that on the 21st of February. Instead it waited until the 7th, or I think the payment is made on the 6th or 7th of March. But then it only stopped uploading candidates on the 8th of March, 2 hours before the deadline. Again, there's no explanation for this other than it didn't understand the system. It thought it had to pay the deposit before it could upload candidates, but it's wrong. It could have uploaded candidates from the 21st of February. And the first complaint it makes, the first time it calls the Commission and says, ooh, the OCNS isn't working, is at 2 o'clock on the 8th of March. Before that, it was working swimmingly. So it had on its own version from the 21st of February until about 1 o'clock on the 8th of March, where the OCNS was working. Mr. Am said that this question, that ACT's understanding that it had to wait to upload candidates until it had paid the deposit is not disputed, but it's fundamentally disputed. And he referred to page 205 of the ACT record, which is this workflow document. It's very difficult to read in this version. There's a much better version, which is TSM 17 in the Labour Party case, which shows the workflow. But if you look at that workflow, what it shows is exactly what I've said, which is that you register the OPA, you generate the payment reference, which happens when you tick the box, and then you can make the payment, or you can upload candidates. You'll see there's this little dotted line over here that goes underneath. This is payment. This is the dotted line to say go straight to candidates. So you can do them both once you've selected the election you want to compete in. But it's even clearer at page 219 of the record, in the user manual, where it says the party will only be able to capture candidates for regions, provinces, where they've generated a payment reference number. Not paid the deposit, not uploaded signatures, generated the reference number, which happens once you select the election. And again, ACT didn't take advantage of physical submission, and it didn't take advantage of bulk uploading. It wasted time. It says it uploaded 120,000 supporters. It only needed to upload 47,000 supporters to compete in all the elections. And if it had done it in bulk, it would have taken it a matter of, once it had collated the information, the uploading would not have taken long. Instead, it spent weeks doing it, one by one, 120,000 supporters. It worked hard, but it didn't work smart. So those are the real reasons ACT doesn't have as many candidates on the ballots that it wants to have on the ballots. There's another point we take about the way that ACT has structured its case, and it really is very strange if we look at their notice of motion, exactly what is the decision they're reviewing. It seems that what they want to review is a decision, or a failure by the Commission to take a decision whether to amend the timetable after they failed to comply. And the Commission's position on this is simple. It has the power under Section 22 sub A to amend the timetable. And that power is triggered when it is necessary to ensure a free and fair election. And it will exercise that power when the trigger exists. But it will not be forced into taking a decision every time a party asks it to take a decision. Because otherwise it would be unduly burdensome. Every time a party or anybody said to the Commission, we want you to amend the timetable, the Commission would have to convene and would have to take a decision on it. And it says, we will do it when it's necessary. And if it's not necessary, we don't have to take that decision. But so we submit that they've gone about it the wrong way. But ultimately it doesn't matter, because if the OCNS worked, then an amendment was not necessary for a free and fair election. If the OCNS didn't work, then an amendment probably was necessary for a free and fair election. So it really boils down to the same question. It's just a very strangely structured case. That brings me to the AASD. There's a couple of problems with the relief that the AASD seeks. The first is that it's not competent. What they seek is individual exemption. If one looks at what they ask for, they say they want an interdict against the Commission to restore access to the system so they can upload their outstanding candidates. But we know from IFP, so the IFP case at paragraph 57, this court does not have the power to grant relief that amounts to allowing the IFP's participation in the election when it has not fulfilled the requirements of the Act. So that type of relief is just not competent. And that's because there was no compliance. Mr. Ramaile tried to make this case of, well, we've done everything except push submit, and that's why there's substantial compliance. That is not their case. If one looks at the founding affidavit in the Electoral Court, paragraph 15, it's not in the record that I have for this case. I'm not sure if it's in the court's record, but the other documents are there, but the founding affidavit isn't. But this is what it says. On Friday, 8 March, the applicant was in the process to capture and upload the AASD list of candidates when the system locked them out at 1700. At that juncture, only one candidate capture template had been successfully submitted when the system lockout occurred. That's their version. Not that all their candidates were waiting in the lobby just for them to push submit. That's never been their case. If that had been their case, the Commission would have given a different answer. I know what that answer is. I don't want to give evidence from the bar, but it would have been a very, very different answer if that had been the case. It's also confirmed in the next day they write a letter to the Commission where they say, we were in the process of capturing and uploading candidates when the system locks us out. But that's not what Mr. Ramahile told me. He said, no, we've got them all, they were uploaded them in the cloud. We just had to push submit. Not their version, and that's not consistent with the evidence that the Commission put up. As far as Section 28 goes, as Justice Majid pointed out, that only applies once you've got in a candidate list. If you fail to provide the nomination form, the signed nomination forms, and the signed declarations to comply with the code, all those documents, you can fix that afterwards, and the Commission has an obligation to notify you. But if the Commission doesn't get a candidate list, then Section 28 never kicks in. On the question of whether the Commission took a decision, the Commission's position is that it doesn't take a decision. And this was recently confirmed by the Electoral Court in the Arise African matter, where it says the exclusion happens by operation of law. So at the moment of the deadline, you're either compliant or you're not. The Commission isn't taking decisions. It's like the Paniti case, which I'm sure the Court is aware of, where a person would lose their employment if they're absent without leave for 30 days. No, the administrator doesn't take a decision, you just lose your employment. It's the same here, you're either in or you're not. The Commission doesn't take a decision. But again, that's a technical dispute that doesn't particularly matter. If we go to why did AASD not comply, the reasons are the same. It waited until a second before the deadline. Why did it wait? Because it misunderstood the system. And when one looks at the founding affidavit in the Electoral Court, what are the reasons it gives? It complains about load shedding. It complains that the Commission changed the time from 9 in previous elections to 5 in this election. And it complains that the OCNS only allowed them to be on for 20 minutes. That particular complaint, the 20 minutes complaint, is disputed by the Commission. No other party raises that. And what the Commission says is if you don't do anything on the system for 20 minutes, it may log you off. If you're inactive for 20 minutes, then it will log you off. That's common in many systems. I'm sure the justices have used their bank. If you don't use the bank, it'll log you off for security reasons to make sure that other people can't take advantage of it. So that's what's happening there. And the excuses of load shedding and changing the time are not excuses. They're just, well, they're not reasons that a reasonable party can rely on to explain why they didn't comply with the deadline. So against all of that, what do we have? We have reasons why for each of these parties we can see the mistakes they made. They tried, but they didn't take advantage of those things. They left things too late. They didn't give themselves enough time to collect all the information. And that's why they didn't comply. Not because the system wasn't operating. That leaves me with just 2 submissions, jurisdiction and remedy. I'm going to say very little about jurisdiction and focus on remedy. We've made the submissions in the heads that this court does not have jurisdiction to resolve cases that are solely disputes of fact. It may be different in direct access cases, but in appeals, particularly appeals from the Electoral Court, where there's no issue of law raised, where it really is just a dispute of fact, this court should ordinarily not exercise its jurisdiction. Whether that's strictly because it doesn't have jurisdiction, because it's not a constitutional matter or an arguable point of law of general public importance, in some cases it will be that. In some cases it may be that the court has jurisdiction, but it should refuse leave to appeal because it shouldn't be hearing those types of cases. The apex court should be resolving legal issues that affect the country as a whole, not resolving disputes of fact already determined in the Electoral Court. That brings me to the remedy. So we submit that there's 3 important principles for the court to keep in mind. So obviously if wrong, we submit the correct remedy is to dismiss the applications, but the court is not with us. The first is that there cannot be exemption for particular political parties. The Commission has a firm view about this, that if the problem was the system, and that's the allegation here, that the problem was with the OCNS system, that affected all the parties. It affected even parties who, like ACT, are partially compliant. They're on some of the ballots, but not on all the ballots they would like to be on. So it's not just the 18 who are not on any ballots. There may well be other parties who say, well, we managed to get on 5, but we would have liked to be on 7. And if the system stopped them from doing it, they should all be given the opportunity, a reasonable opportunity to nominate the candidates they wish to nominate. So that's the first principle. The second is that if parties were excluded from competing, so if on the OMSA test, the Commission didn't design a system that allowed reasonable political parties to compete, that would ordinarily render the election not free and fair. And that brings me to the third principle, which means there would have to be an amendment of the timetable. an amendment to the timetable will result in a postponement. And the reason is what's happened since. Because if the opportunity for candidate nominations is reopened, then the Commission goes back to where it was on even before the 8th of March. And there'll have to be a certain number of days for parties to submit further nominations, and then the Commission will have to go through the Section 28, 29, 30, and 31 process, which normally takes a month. Could probably be condensed, but still, it's a process. You've got to check all the candidates, you've got to put the lists out for objections, you've got to decide the objections. It takes at least weeks to do. There's got to be appeals, there's got to be Electoral Court, those appeals might end up in this court, one is on Friday, and that takes time. And the Commission, only once that process is finished, can it print the ballots. It's already printing ballots. If it has to go through that process, it will have to start again, and the ballots will not be ready. Because the ballots for the national election have to be ready on the 17th of May, which is just 11 days away for the overseas voting. And so the Commission says it cannot do it. It does not have a solution like the IFP stickers in 1994. And I think part of the reason for that is that the electoral framework now is much stricter. 1994 was in some ways a rough and ready election. Now we have strict electoral requirements that we have to follow in terms of the Electoral Act, that unless the Commission suspends unless the court suspends the operation of that legislation, the Commission must follow. And so it doesn't see a way that it can permit all the parties an opportunity to nominate candidates and be ready. And so that leaves the court with a choice to require the Commission to amend the timetable, to reopen the window, which will lead to a postponement, or to provide another remedy that will not as effectively vindicate the rights of the applicants. And the one proposed in the heads of argument is a declaration that their rights have been limited. And I accept that that is a poor second prize for these applicants. Because it doesn't get them into this election. But this court has to grapple with what is just and equitable, and what are the costs of postponement. And the costs of postponement are more than R500 million in costs. Just briefly on the registration, the Commission has to have a new registration weekend to ensure that voters are registered in the correct province before the election, so it can't have so long before the last voter registration weekend for the next one. And it will be disruptive for political parties. The Commission has provided that evidence, but it's also common sense. Political parties have been campaigning and planning for an election on the 29th of May. They've spent their money on TV adverts and posters with that in mind. That money is now spent. If the election is postponed, they will be negatively affected. We don't need evidence from them to know that. And so the court will have to choose between fully vindicating the rights of the applicants against the immense disruption that postponement will cause.
It appeared that you actually reached the end of your submissions when the bell went.
I was following the clock very closely, Deputy Chief Justice.
Okay. Mr. Bishop, ACT objects to the admission of lockdown's confirmatory affidavit, and is it annexed up here someone to the Commission's answering affidavit?
Yes.
Which it complains introducing evidence on appeal.
Yes, that's correct.
Now, I want to find out from you if the Commission should not have filed a substantive application.
I believe we did, Deputy Chief Justice. There is a notice of motion, and the justification is given in the answering affidavit. There isn't a separate affidavit for the application to introduce new evidence, but there is a notice of motion, and the justification is in the answering affidavit.
All right, I missed that document.
I know that one was prepared. I hope it was filed. I'll double check.
Two of my colleagues confirmed that they have actually cited it, but perhaps you can help me because I don't have it now. What is the justification? Why was this evidence not led in the Electoral Court?
Yes, so a report from Lockdown IP was put up in the Electoral Court. I think it's important to note that the Electoral Court operates on extremely tight timelines. So I believe in this case, I think in ACT we had 2 or 3 days in order to put together an answering affidavit. And the lockdown report that was put up there was the one that was put up. Subsequently, particularly when we've got the Labour Party affidavit, we consulted again with Afrikan because this was a fresh application that required a fresh answer. And we got a additional report and a confirmatory affidavit in the Labour Party matter, which has been put up, and we can't put it up because it's a first answering affidavit. We took the view that given we put up a version of it in the Electoral Court and the ACT matter, and we were putting up a different version in the Labour Party matter, and the cases would be heard together, it was fair for us to also seek to put it up in the ACT matter so that they would have an opportunity to deal with it. It's not substantially different from what is in the Electoral Court, but it's a more complete version, more substantive version of the same basic evidence.
The service provider claims that the system was 100% functional throughout the material period. But in various parts of the Commission's answering affidavit, it is not disputed that there may have been glitches, the system may have been slow, froze, hung, whatever that means. Now, I want to know what one is to make of this seemingly contradictory evidence. What does 100% functional mean?
Yes. In the affidavit, what the 100% uptime means in the affidavit of Mr. Sukunan. So he explains what it means, because I separately put it together, what does 100% uptime mean? And the explanation is that the website demonstrated exceptional stability and showed uninterrupted access for users. Such a high level of uptime is indicative of a well-maintained and resilient website infrastructure capable of handling potential challenges and maintaining consistent online performance. So that doesn't mean that there may not have been, the Commission cannot responsibly say to this court that these political parties are all lying and none of them ever experienced any glitch or any runoff or anything like that. We can't say that, we don't know that. What we know is that there may be other reasons for that are not related to the system, that may be related to their internet connection or the computer that they're using. Or there may be small gremlins that happen in the system occasionally. We can't say for certainty that didn't happen. What we know is what our service provider tells us, that generally it was capable of handling potential challenges and maintaining consistent online performance. So I don't think those two are necessarily contradictory. I think you've got to read that overall it was working well. There may have been some small problems. Some of those were probably had nothing to do with the system and were caused by the particular political party's connection. Some of them may have been small glitches in the system, but they weren't so big that they prevented feasible parties from complying. Again, the standard is not perfection, it's reasonableness.
All right. Last question. You have made a proposal that if we find in the applicant's favor, we grant a declaratory order which you yourself have considered is exceedingly an exceedingly poor second prize.
Yes.
Now, I want to ask if there is any other appropriate remedy at all that you could grant that would mean something to them, short of amending the timetable and the unthinkable of postponing the election.
The difficulty, Deputy Chief Justice, is the only thing that would really satisfy them is something that would allow them to compete in the election. And unfortunately, because of the delay, and the delay is not their fault, the delay is a result of the litigation process, but it is what it is. And today, there is no other remedy the Commission can provide for these applicants.
And of course, either way?
Yes, Deputy Chief Justice, if the applicants, if the applications are dismissed, the Commission, it has said in its affidavit that it asks for costs. It seems to me that Biowatch would apply in these cases unless the court concludes that the applications were frivolous or vexatious. I leave it in the court's hands. If the applications are successful, there's conflicting dicta. There's some, like in Kloppe, this court ordered costs against the Electoral Commission, but there are other cases such as in Electoral Commission versus Democratic Alliance in the SCA, where the SCA held it was inappropriate to order costs against the Electoral Commission when it was performing its regulatory role. We would submit that the same is true here. The Commission has acted responsibly as the regulator, and that if it is unsuccessful, there should be no order as to cost against it for those reasons.
All right. Thank you.
Mr. Bishop, mine is just housekeeping for myself.
Yes.
This point that Mr. Loxton laid much emphasis on, of the 35%, I couldn't keep pace with you with the submissions you made as to where that particular passage of the evidence is to be found. So my note is incomplete, so I really just want to complete that note. You say that that 35%, and I think I did pick it up somewhere, probably in your submissions, that you say it doesn't mean that that 35% did not comply because of OCNS malfunctioning. Can you just make that submission again for me, please? I just want to make a note.
Yes.
And also where it is in the papers where you answered it.
So maybe the sequence is important. The Labour Party's attorneys wrote to the Commission asking for various pieces of information, including how many unrepresented parties were unable to compete because of the OCNS. The answer is given in the Commission's answering affidavit, paragraph 108.2.
Sorry, 1842.
108.2.
Yes, okay, I've got it.
It's page 35 of that affidavit, where the Commission makes clear that 18 unrepresented political parties that sought to participate in the national elections did not meet the requirements to do so. But the Commission doesn't say, because it doesn't know, why they were unable to do so. It knows that they registered an OPA, and so they obviously indicated an intention to compete, but that they didn't meet the requirements by the deadline. But whether they didn't upload sufficient signatures or candidates because they had difficulties with the system or because they didn't have sufficient signatures or candidates, the Commission cannot know unless the parties tell it. So it's not really very helpful information in assessing how effective the OCNS was. It doesn't tell the court very much.
And I mean, these are voluminous papers which we've had to read constantly over the last week as they streamed in. But is there any way in the papers, can you help me, is there any way in the papers that gives statistics of how many represented parties were able to register, were able to comply with the deadline?
So I think the best reference is that there are 14 represented parties. So ultimately, these numbers, I think, changed a bit. In the Electoral Court, you'll see the number of 87. And ultimately, the number, can you just find the reference for 70? It's 70 political parties that are on one or more ballots, 56 unrepresented, and 14 represented.
Thank you. Thank you.
Yes. So, sorry, one second, just get the reference for that. So in the ACT papers, in the Commission's answering affidavit, page 20, paragraph 68.
Thank you, Mr. Bishop.
Mr. Bishop, it's late in the day.
Yes.
You've been on your feet for an hour. Let's see whether we can cut to the chase. The easier or the neater way of dealing with this case, correct me if I'm wrong, or clarify me. If we find that there was a dispute of fact, which the parties could not approach us, we could dismiss it on that basis, and we would find also that the Electoral Court applied the principles in plus connivance correctly. And that would put paid to the application by the ACT and the AASD.
Yes. And I think that the court could just say it's not in the interest of justice to grant leave to appeal because it's purely a dispute of fact without necessarily having to delve into the intricacies of jurisdiction.
Okay. And as far as the Labour Party is concerned, we would have to say that approaching this court by way of direct access, it misconceived the position.
Yes, and that it's refusing, it's not in the interest of justice to grant direct access for issue estoppel because it was possible for it to bring the appeal and still seek the relief that it's seeking. Yes. That is definitely the quickest.
That's a cleaner way of dealing with this.
Yes, Justice Mutov.
Thank you.
Mr. Bishop, thanks very much for your submissions. I want to ask you a number of questions. The first relates to your claim that this court doesn't have jurisdiction over factual disputes. My understanding is that when rights or constitutional issues are violated, there will often be factual situations which require us to determine if there is an infringement of a right and whether that infringement is permissible. There are a number of cases. SAFU, for example, says it wasn't a rights case, but say in the event there can be no doubt that this court is obliged to determine factual issues where they relate to constitutional issues. You cited ANC versus IEC, which actually involved factual disputes around the ID numbers of a Mr. Maluleke, and the court adjudicated that dispute. So I wanted to put those examples to you. Evictions cases come to mind as well, where they're very factually implicated. And given that we have a claim that's made on the basis of rights, on what basis then can we dismiss on the interests of justice do not allow us to consider a factual dispute of this kind?
Yes, thank you, Justice Vilches. I wouldn't say that this court cannot consider factual disputes, that they will arise. The question is whether when a case, there's no legal dispute in the case, there's only a dispute of fact. Even if it concerns a constitutional issue, whether in those circumstances, I think there's two levels. One, whether the court has jurisdiction, and two, if it has jurisdiction, whether it's ordinarily in the interest of justice to grant leave to appeal, where it's only a dispute of fact. And what this court has said is it is an apex court, and the normal relief for where lower courts get things wrong on the facts, even in constitutional matters, is an appeal to the next higher court, not to this court. This court exists as an apex court to set the law, not to get each case right. And so for that reason, it either isn't in the interest of justice or it doesn't have jurisdiction. The additional level is particularly with electoral matters. The section 96(1) of the Electoral Act says that the Electoral Court, that there's no appeal or review against any decision of the Electoral Court. And this court in ANC says, well, yes, there's no appeal or review unless it's a constitutional matter. But that decision only makes sense if you identify a category of electoral cases against which there is no appeal or review. And it seems to me that the one way to do that is to say, well, where there are purely factual disputes that have been resolved by the Electoral Court that do not raise any issue of law, that would be a category to which 96(1) can still apply. But I accept that the general proposition that it stated that highly that this court can never resolve disputes of fact, that's not correct.
Okay, thank you. The second point I wanted to raise with you is, like, the impression on the papers to me is that on the IEC's own admission, there was a number of complaints about the OCNS system, about hanging. And the IEC essentially then says, well, we're not considering amending the timetable. These are complaints, it's your fault, and doesn't actually respond, in some senses, to the complaints before it. Section 1951E of the Constitution directly recognizes that people's needs should be responded to by organs of state. And so my question to you, and that's my trouble in this case, does not an organ of state like the IEC have a duty to be responsive to the problems that are drawn to its attention? And if I have a look, we sort of quantified these. 12 parties, I know we may or may not admit these, said the portal malfunctioned. 7, the portal's payment function was not working. 9, that bulk uploading difficulties in the portal, including uploading of signatures. At what point does an organ of state actually say, well, there is some problem here with the system, and we're going to try and act in a way to enable people to stand in the election and amend the timetable if it may have been by a week, for instance?
I think just there's different forms of responsiveness there. The one is responsive to the complaint. So somebody sends an email or phones and says, I'm having difficulty with this. And the evidence is that if one looks at the Labour Party and the ACT cases in particular, that the Commission did respond. And in many cases, it provided a useful response. Sometimes it didn't. In the Electoral Court, I can't remember exactly what the details were, but there was a question about why didn't the Commission just tell this party that this was the way to do it. But the Commission only knows the problems that the parties bring to its attention. And so I think the evidence does show that it was responsive in that sense. Of course, the Commission has limitations. It doesn't have an unlimited number of staff. This is a busy time. It may not have answered every complaint immediately, but I think really the Commission's officials tried very hard to be responsive. So that's the one level of responsive to complaints. And there may be a complaint that this isn't working, and that may be because you're not using it properly. That was the case with the one example I gave with the Labour Party, where they were using the wrong tab. And those could hopefully be solved. Or it may be a problem with that particular party's internet connection, which the Commission can't solve. Or it may be a problem with the system. But the fact that the complaints exist at a time when many political parties would have been using the system doesn't tell us that it's the system that was malfunctioning, when you have all the other evidence showing that it was still working. With regard to the second question of whether it was the Commission, in order to be responsive, should have amended the timetable, the Commission could only amend the timetable if it was necessary for a free and fair election. That's a statutory precondition. And so it had to be satisfied that the amendment was necessary. And if, based on the evidence it had before it, it said, but we've given people enough time, we've given them enough training, we've given them a system that if they use it properly, they'll be able to comply. And that as soon as we start changing deadlines, maybe they could have changed by a few days without impeding the rest of their performance, but every change has knock-on consequences for the rest of the election timetable, which means everything else has to be done faster, which creates additional risks down the road, that you only amend when it really is necessary. And so I'm not sure it shows non-responsiveness that the Commission didn't amend.
And that's one of my worries. I mean, this court is held in different circumstances, I accept. Like in Mazibuko, for instance, the Constitutional Court recognized that flexibility is an essential part of reasonableness in some senses, and I understand that the same standard doesn't necessarily apply over here. But it seems like the election timetable was set, and almost nothing could deter the IEC from actually keeping to that timetable without, even with many, many complaints. It didn't seem to be prepared to be flexible in any way, and I'm worried about enshrining that inflexibility into our law.
I think in this context, Justice Pilchard, that rigidity performs an important constitutional function, that it provides certainty to political parties, and this is what the case law says in the Liberal Party IFP, and if one looks at, I think it's a good party case in the Electoral Court, which says that the importance of adherence to timetables is also to allow the Commission to perform its function. And again, there's a statutory precondition. And so it's not enough for the Commission to say, well, we'd like to help you out, and so we can. It doesn't have the statutory power to amend the timetable unless it reaches a conclusion that it is necessary for a free and fair election. And so that comes back to the fundamental question, which is if the Commission had provided a system that, on the probability that a reasonable party could use to compete, then it's not necessary to amend the timetable. And there are risks of doing so to free and fair elections. And so there's a degree of balance in there. It's not just a question of one way. More flexibility is always good.
And the last set of discussion that I wanted to have with you was around, and I thank you for addressing my concerns around Plascon evidence in this context. I am worried that in context of election disputes, what Plascon evidence essentially does to any party coming before an electoral court or before this court is essentially say, well, we don't have action proceedings available. We generally have to come on motion proceedings. Therefore, the IEC's version is almost inevitably going to be preferred. And so what you do is essentially you load the dice against parties seeking to enforce either their right to vote or their right to stand for an election. And so I'm very concerned that the way in which we utilize laws, an evidentiary rule in this context, is going to actually inhibit the ability of individuals to actually give effect to claims to address possible infringements of their right.
I think I'd have a few responses to that, Justice Pilchard. The first is the commission is often an applicant in the Electoral Court, so it's not always the commission that has the benefit of Platskon evidence. I've brought multiple cases for the commission in the Electoral Court where the commission has the burden of Platskon evidence. So it depends on the case. The second response is Platskon evidence is not. In order to get the benefit of Platskon evidence, you can't just deny. You have to put up a positive version. You have to put up a version to show why you say the applicant is wrong. If you just say I deny it, then often, even on the application of Platskon evidence, the court will accept the applicant's facts. And I'm not sure why election disputes should be different from other constitutional disputes, which are resolved on Platskon evidence. I accept that because of the urgency of elections, it's often very, very difficult or even impossible to have oral evidence. And although that, again, it isn't always the case. Sometimes electoral matters are not urgent, but it is normally the case. But there's also a risk of doing it the other way, because then you put the commission in a very difficult position, and you put the court in a very difficult position of analysing probabilities merely on affidavit, which is exactly what Platskon evidence is designed to avoid. And also, I made a submission earlier, but I would be hesitant about changing the law in this case, where the issue hasn't been fully argued or debated by the parties.
Yeah, well, I doubt Platskon evidence will be, in general, it will arise, the issue will arise in the course of other proceedings. In general, it will be unusual to have a full frontal challenge to the rule itself, and I imagine it would develop according to various particular cases where it's shown to be inadequate. And I suppose you put forward the reason in this case would be urgency and the particular nature of the fact that there's no alternative. My sense of the underpinnings of the rule is that an applicant could have gone on action proceedings in other cases, and therefore, if you decide not to, the respondent's version is preferred. But in these cases, that isn't a possibility, and so therefore, there's a question of whether the conditions for the application of the rule are actually here.
Yes, I accept it is different. I mean, there is a similarity in review proceedings, which I think Mr. Am referred to, which do also have to be ordinarily brought on motion. You have to have a special application to go to action proceedings. That the difference is you get the record, but that doesn't necessarily change the question of how the disputes of fact are resolved.
Thank you, Mr. Bishop.
Shall we take a short comfort break, just for 10 minutes until go request?
As the court pleases.
Judgment.